Thursday, July 10th meeting of the Albany Community Police Review Board. Oh, God, I forgot. No, I couldn't hear it. Albany Community Police Review Board. I'm Antoinette Santos, and I'm going to ask John Lewandowski to do the roll call.
Ms. Santos?
Present.
Dr. V?
Present.
Emily?
Present.
Victor? Present. John Lewandowski, I'm present. And via Zoom, we have Batman joining us. Batman present. I think he's trying to log in right now. All right, and we have via Zoom, we have Batman. We have quorum, and we're ready to start.
Okay. So, first order on the agenda is the approval of minutes for the May 22nd, 2025 meeting. I have one proposed amendment that I just want to bring up to everybody. And this is simply for memorialization purposes. On page 4, you read that the report from the chair, Chair Vivas announced her resignation effective June 17, 2025, as her new role creates a conflict of interest with her CPRB work. So that was the reason that she had given of what her resignation was for. However, in our body of notes, there is no mention of a successor. So I just wanted to know if perhaps we should put in a line stating that the bylaws indicate that the vice chair moves up until the next nomination, the nomination of the new chair, and I believe that happens in November. So I don't know if we should just throw a line in stating that we do have a chair, because right now it looks like it's open. Okay?
Madam Chair, if I may. After you brought that to my attention when I distributed the agenda last week, I went through and made your requested revisions, and I provided them in the new packet. So the new packet says that the special election that was held last month made you chair, Mr. Lewandowski vice chair, and Ms. Swowek secretary.
Okay, was that in the packet that you provided today, this
Yes,
morning?
ma'am.
Okay, today, okay.
And
So-
it should be in the reflected in the hard copy in front of you as well.
Okay, perfect. Okay, that was my only question, so it's already done. Is everybody okay with that?
So do we make a motion to accept that then?
Yeah.
Okay, I'll make a motion to accept the adjustment with regards to our positions. Second?
Second?
Emily seconds. Thank
Okay.
you. Everyone in favor, raise your hands. All right. Batman, thumbs up. Thank you, Batman. Obviously no opposed and no abstentions, so it carries. Thank you.
Okay. There was one change to the agenda which was taken care of by Garrett Schaff, our program director. That change was made this morning. Everybody, I'm sure, knows because everybody was told via email that there would be one change to the agenda, okay? So we're going to go into public comment. Each person that would like to speak will have a total of 3 minutes during this period. And we'll let you know when the time period is over. Is there anyone that would like to speak for public comment?
Good evening, everyone. My name is Himmler Francois, and my comment relates to a case that was brought before the board. Nonetheless, I don't see it in the agenda listed. I believe the case number was Charlie 2022-001. And I sit here, my question is, I believe it was back in 2022, and I do understand that the board have had several hurdles to overcome in the past year and so on. However, last time I was here when the agenda was on before the board, it was tabled to be discussed at a later date. As of yet, I have not found any updates in that regard, any correspondence. I did go back, retrieve more information and provided them. And here we are from December 2021 to now, still no answer. And I do understand there's a lot of things that take place. However, I also believe that justice should never be delayed, regardless of the circumstances. There is a period of time that someone should be waiting to feel that their voices was heard. And me being someone who also travels a lot, it's a bit annoyed because I have to keep track on when things are being brought to the board to make sure that I'm here. And sometimes when the meetings take place, there's no notice that goes out on time enough to inform the public that the meeting was canceled. There were a couple times I showed up for meetings and there were issues between the board and the city and so on and so forth as they were transitioning. So, you know, those things, I do understand they take place. However, for the citizens that are involved, I think the board should try to alleviate, you know, further burdens onto those citizens that are involved here, who has to appear here, who constantly have to keep track of what's going on in regard to their complaint, because it only adds to some people. Some people can handle stress and some don't. And being known as a board that can resolve issues can only be beneficial to everyone, compared to being known as the board where, oh man, they've been working on my case forever. I don't know when there'll ever be a solution or there'll ever be a mediation in that regard. So I just want to know what's the status, what's going on, why isn't there a constant channel record or communication between the board or whoever's in charge to communicate with the complainants, because I think it will only make things easier for everyone and less frustration, because I've never seen anyone come here angry, and I hope they never do. You know, it would only prevent certain things, you know, and I congratulate you guys for the things that you do as you find it within your schedule to do these meetings. However, I think a little bit of diligence could help as well. So I simply hope someone can enlighten me.
Thank you for your comment. We do appreciate your feedback with regards to that. The board member that is assigned to your complaint, I will have him reach out to you. I think he did try in the past while you were in Haiti, but I'm not, apparently that wasn't able to contact you. So we'll make sure that we'll give you abreast of what's going on with your case, because it was heard but tabled. I will work as the investigating chair to have it we're hoping to have an August meeting, if we're able to get quorum for August, and we'll hope to have that on the docket. But I will have the board member responsible for your case to reach out to you to confirm your availability. Okay?
All right, that's fine. But just to add to that, I did speak with Batman, I believe, and I did provide him the extra information that I had, and that's actually what I want to follow up from, because I think it was the end of last year, I provided that. At least by now, I'm hoping there should have been something, some type of communication. I'm not saying it's from his side, but, you know, whoever's, yeah.
No, and we definitely want to keep you abreast of anyone's case, what's going on. But thank you very much for this information. We really appreciate your comments today.
All right. I look forward to hear. Thank you.
All right, something?
Oh, Batman, I believe he's going to just respond.
Yes. No, you're absolutely right. And for what it's worth, I definitely appreciate, you know, your patience, and you've been working on this a long time. And it was very helpful that you provided additional, you know, information for me to review and stuff like that. And there have been other hiccups across the board as we figure things out. So I definitely appreciate your patience, and I'd also offer that you connect with Garrett and find a time that works around your schedule, and we can have a meeting where you can come in and we can have that conversation and establish like a concrete timeline. I think John's absolutely right with we can push to make that happen in August. And also, I think having contact with Garrett will give you another contact in case you want information about meetings or any other questions. You'll have an additional point of contact for those things. Definitely appreciate you, you know, being on board for this process and your patience along the way.
Thank you very much, sir. And just to mention, I know that dealing with, I like the name Batman. Because of the Batman, I never remember his real name. So we have, I can say we have had a very good relationship in coordinating to exchange these, and I really appreciate all the time that he has made available to meet with me.
Thank you very much.
Are there any additional public comments?
If I may, before you step down, Mr. Francois?
Yes.
I have your email from the last time we spoke, so
That's
if you would
correct.
like, I can add you to the email distribution list, so when I send out, when we notice meetings, there's a distribution list that gets sent out to notify individuals. Would you like me to add you to that list?
I did sign up for the meeting notifications.
Okay.
I do get them. It's just when the cancellations take place last minute, because when you trying to make it down here from Saratoga,
I understand, and that's something that I think we can all work on as a group to, now that there's a program director in place, so.
Thank you, sir. And I hope to talk to you after concerning what we discussed last time.
Absolutely.
Are there any additional comments online? Garrett, do you see anybody? Hands up? I don't see anything. Okay, all right, thank you. We'll move on in the agenda. Are there any board member announcements? Okay, there appears to be none. Oh, I'm sorry. Communication from the City of Albany, Detective Lieutenant Riddy, would you like to speak?
Hi there, everybody. So I'll give some of the normal stats that we normally give out. Since our last meeting, we have closed and or forwarded a total of 4 complaints. So they've either been submitted to to either myself or to the board, and then we've received 6 complaints since the same time frame. Other than that, there's not really any new news to report. So unless there's any questions from the board.
Thank you, Lieutenant.
The report from the chair, I'm going to defer for new business. CPRB committee reports, bylaws, and rules, I'm going to defer, I will defer until new business. Community outreach, Paul?
Yes. So I've been working with the community on a bunch of different things. This summer has been, unfortunately, very active. There's been a bunch of problematic incidents. In a bunch of them, I've been able to work with the chief and have a good line of communication open between him and the community when we're looking for additional information, for resources, or for even guidance about certain things. That's going well. So we're looking to keep that up, and we have more meetings coming in the community with other people who want to work with law enforcement, and at times when they have issues, having a helping hand to help navigate those things. Events coming up, we're going to be tabling on the 19th. On the 19th, we're going to be at the MVP Arena tabling with Alert, and that's the Albany Law Enforcement Resolution Task Force. There's a big community day where everybody's going to come in, family-friendly games and everything else. A great opportunity for us to interact alongside law enforcement with the community to show that, again, we're working in coordination with each other and we're a resource for the community. So a bunch of outside events, and when things happen in real time, we have good forms of communication open to kind of work with the community.
Was that it, Batman?
Yes.
Okay,
Sorry.
thank you very much. Thank you. Investigations, John?
Since we have a pretty full docket tonight, I'm just going to hold off on my usual report to let more time for the investigations themselves. Just to note that we do plan to present reports in August, when we usually do not have an August meeting, but since it took this year a little bit time to get off the ground with staffing and other stuff, we're going to attempt for an August meeting so we could start processing more complaints. That's it.
Okay, thank you. Mediation, Dr. Harden.
Nothing new, Chair Santos, thank you.
Okay, thank you very much. Police Department Liaison, Dr. Harden.
It's yeah, so, no, it's worse. So we are going to resume
Dr. Harden, if I can get you to try speaking the mic a little louder, because we couldn't hear you, so I just want to make sure it's recorded for the record.
Thank you. Should I repeat it? Are we good? The change was reflected in the minutes that the police liaison chair is Lewandowski. It just wasn't changed on here, but the record should just to reflect John Lewandowski is the chair of the police department liaison going forward.
Yeah, and we're going to start our police liaison meetings as a monthly meeting. We're working out with Lieutenant Reddy the best time to do that, and we will start those again shortly.
Public official liaison. I don't have anything official as of yet to say, although this question did come up at a meeting with Common Council member Hoey and others, that they would like to commence the public official liaison meeting, and we will be commencing that. Also, who's going to be involved in that will be Julie, right? Julie. I think Julie's going to be coming back. I believe Julie and T&M will be involved in that. Julie, are you on right now?
I'm on, but I could barely hear you guys.
I'm so sorry. Am I misinformed that you will also be involved in the public official liaison committee meeting shortly? That they should be commencing again?
I don't know if I'm part of that committee. I don't know if we shored that up, so
Okay.
I don't want to speak as out of turn.
Okay,
But I think we discussed at the investigations meeting that it was going to start again.
okay.
And I think you might have wanted us, or me to talk there about some of the issues, but I don't know if I would be like to be a member.
Yeah, I
of the
don't think it was
committee.
this. I think it was a particular item to be brought up, not necessarily a standing spot.
Okay, thank you, Julie. Old business, is there any old business to discuss? Okay, on to new business. There's going to be a presentation of bylaws and rules amendment. Since the board has been incorporated into the city by operation of Local Law D, there is a need to clarify the interplay between the board and position of program director. in relation to certain important decisions that impact board operations. I believe that by clarifying some of this, any confusion of or disruption of board operations caused by a lack of clarity as to the interplay between the board and program director will be resolved, and the board's independence we have fought hard for will become more secure. Before we get to the amendments themselves, I recommend the board waive the normal Rule 12, which relates to the bylaw amendment timeline. That rule will require that the board wait until the next meeting to vote on proposed bylaws. Given our need to ensure the board operations continue without any disruption, it is imperative that we move quickly, especially in light of the complicated situation the board is in as it is incorporated into the city. So I'd like to open that up for discussion right now.
I'd make a motion to waive Rule 12 with regards to your request. Is that correct? Do we have a second?
Do we have a second?
Second.
All right, Dr. V seconds. All in favor, raise your hand to say aye. Batman, how do you vote?
I put a thumbs up. I wrote
Thumbs up, there you go, yeah, thank you.
Thank you. I didn't see it.
All right, no nays, no abstentions, so it moves forward.
Okay. So that is passed. The motion is passed unanimously. There are 6 votes in favor of waiving the normal bylaw amendment rules in order to consider the implementation of new bylaws which address threats to board operations created by a lack of clarity in local law D. So this is motion 2. Now that we have unanimously voted to waive the normal bylaw amendment rules, in light of the concerns raised related to operations of the board, we can now consider the actual amendments themselves. These amendments are intended to clarify the nature of certain decisions that have significant impact on board operations. As we discussed, Local Law D makes clear the program director position is intended to work at the direction of the board under the supervision of Common Council. These amendments make clear and reinforce, consistent with Local Law D, the expectations of board interactions with the program director position now or in the future. And for all the board members, our program director forwarded the confidential report on 7/3/2025, which detailed the proposed bylaw changes. So I'm going to open this up for discussion right now, if anyone would like to discuss this. Are there any questions in what was proposed? Jake Iceland, yes.
So I had a question on 1, I think 2, 3, and 4 seemed fine to me. I did have questions and comments on 1, 5, and 6. So with 1, amendments are done by the CPRB. The program director isn't amending the bylaws himself. I'm not sure why the bylaws would need to reflect that the program director can't amend them, because that's just not something he does. And then on 5, official communications the program seeks to make to any entity, that's, the program director couldn't talk to HR if there was an emergency, couldn't talk to the Common Council, like, that is way too broad. I think you want something like official statements, but I definitely think that is far more broad than you want. I think if that were enacted, I'm not sure what the program director could do on a day-to-day basis without calling and waiting for a meeting of the entire CPRB, as you said, because it has to be a majority vote of its membership. And then on 6, I have worries about, I totally understand like implementation and termination, but for modifications, you know, if there was a tech support issue and that needed to get changed, they wouldn't be able to resolve any of those sorts of things unless there was a full vote by the CPRB, and being that those are monthly things, I really don't think 1, 5, and 6 are workable as is.
I'd like to defer to Kevin Canizaro. Kevin, could you assist us in this matter? Yes, please, my apologies.
And just to reflect, Kevin is our independent counsel with the CPRB.
Okay, it's already on. I don't have to press the button anymore. So, Jake, Mr. Iceland, what do you want to call him? I'll call you Jake because we know each other pretty well. So I'm going to take each of your, well, I'll start with a general statement as to the impetus for the amendment itself, but then I'll go through your comments on 1, 5, and 6, right? So obviously, as Chair Santos said, the intent of these amendments are to bring clarity between the relationship of the board and the director, where there really is no clarity in the local law. The local law, and the board will be coming to the council with some amendments to the local law, but this is a preliminary step. The local law is very broadly written and doesn't have specifics as to that interaction, so the board thought it was very vital to ensure continued operations of the board, that some of these things were clarified as far as the law is clear that the program director position works for the City of Albany under the supervision of the Common Council, and importantly, and it's in the definition of the program director itself, at the direction of the board. So what these amendments say is what very vital, so the board made a decision to pick 6 very critical areas, not everything the program director does, just to kind of address that broad comment. These are 6 tailored items that the board thought necessary to put into the bylaw amendments. Obviously, the program director retains the authority to do the world of items that are outside of those 6 things without having CPRB, approval. So that's the first comment. As to 1, I agree with you. So subdivision 1, the program director would not normally have any ability to unilaterally, and I'm talking about the position, whether Mr. Schaff or some program director in the future, we agree. The program director would never have the ability to unilaterally amend the bylaws, which is what you said, I think, right? Right. So this is here to just enshrine that. There have been some misunderstandings about that process since January. Because it is nowhere clear in the law, other than the director works at the direction of the board, we thought it necessary to make that very clear. And
just a question. Let's stay on 1 so that we can go one by one.
Bylaw amendments.
So that sort of makes sense. But if 1 is already prohibited under Section 1A of Article 12, these bylaws and rules may only be amended at a regular monthly meeting of the board, provided that, right? Like, if that is already explicitly in there, and we're not adding any more clarity. Like, I understand if you want to add more clarity,
right,
but I don't think any additional clarity is being added here.
Well, the board believes clarity is needed, and it's their sole discretion to amend these bylaws. So that's solely a decision of the board. If you look at the rules of procedure, and I'll take you to Rule 11, Mr. Iceland. Rules of procedure, the very first section speaks to amendments of the bylaws. So back many years before this Common Council existed, well, this current iteration of the Common Council, when the board was formed in 2000, you probably know the Common Council already approved the initial bylaws of the board. And that was under the procedure of the initial set of bylaws. So as Section 1 reads, the board itself was given full discretion to make subsequent amendments on their own, independent of any other action. So respectfully, Mr. Iceland, this is a choice of the board.
Understandable. Look, and if we all agree that no actual laws are functionally being changed, then I guess you and I are wasting our time talking about it.
I think it's
move on to 5, because we all agree that.
I think number 1 is a fully discretionary decision of the board that only the board has the right to make.
It reminds me of legislative intent that people love to put in, but it doesn't always actually.
So I think I've addressed number 1.
Yeah, absolutely.
Okay. Number 5 I'll go to. So number 5, I'm sorry, what was your critique of number 5?
My critique there is that official communications is way too broad. And official communication could include a response to HR, a response to the council itself.
Yeah, the board again, and this is their discretion, wants to make clear, and they're willing to wait for each monthly meeting to give that authority. It's very important to the board that any program director act at their explicit direction on that item. They're willing to wait a month in order to do that. That's not a concern of the board. I've spoken to all the board members. So your concern about delay, what's more important to the board, Mr. Iceland, is that the program director is following their explicit direction as it relates to official communications.
And so I understand that that is the concern of the board. I will certainly bring that back to the council. You had said that there's a world of other things that I guess are beyond official communications of the council. I'd be interested in hearing some of those things that you think would not count as official communications.
Well, official communication is a term of art. So, and that's been used throughout the board's history. And we use an example of communications, you know, as a decision of the board.
So I don't need to know an example of a communication. I need to know an example of like what wouldn't be a communication.
Well, I think I want to answer your question, Mr. Iceland. I would appreciate it if you let me give the answer. The reason that we put in an example is so there's no misunderstanding of what not only is official communication a term of art, we gave a specific example so that what you're worried about would not be a concern. Nobody's suggesting that, you know, every phone call, every day-to-day thing that the the program director does need to be clear. It's certainly not. And I think that's a very narrow and not quite accurate reading of the clean term of art. So I don't think your concern is going to manifest. An official statement is a term of art, and I think we all know what that means.
So then what would you consider the difference between an official statement and an official communication? Because you've specifically chosen the language official communication, which I certainly, and I think you agree, is far broader than official statements.
So what this says is official communication, Mr. Iceland. That would mean a communication by any program director on a matter of concern for the board, made on behalf of the board on that issue.
So how would we know that something's a matter of concern?
So I just have to clarify something. The board, again, has full authority to adopt these amendments without the need for any type of authorization from any entity. You agree on that, correct?
Unless those modifications are inconsistent with local law D.
And what about 5 is inconsistent with local law D? Tell us.
I believe a lot of the responsibilities of the program director are explicitly enshrined in local law D, and this distinctly limits those so that the program director cannot fulfill those responsibilities.
It seems you're reading this amendment in a very particular way that is not in front of you.
Then why don't you add more specificity? Why are we waiving the delay and just going ahead
Sir,
with it?
I'm curious as to, the council has never taken this level of interest. The board has amended their bylaws at least 5 times in the last 3 years. Never once has the council made any sort of critique at all on them. It is interesting, and we can discuss at a different date, the renewed
I'm
level.
sure we've had plenty of conversations, Kevin, and we will continue to.
Sure, we want to know, we'll get into that offline. I mean, I think it's interesting, this significant renewed interest in something that's happened as a matter of course over the last 5 years regularly. So we can talk about that offline.
I'll say, you know, as I said, most of these I think are fine. I truly believe that official communications would limit the program director from performing any of the functions that they are hired to do.
We disagree.
And I'm waiting for examples to the contrary.
The board disagrees. So that's the answer to 5. 6, decisions related to the implementation modifications to, and which part of this do you have an issue with?
This one I thought modifications as well was too broad. I think that if the system crashed, they couldn't even call and fix it without waiting for a public meeting to approve fixing whatever caused it to crash.
Again, Mr. Eisen, I think it's really important for yourself to understand, because I know you'll relay this discussion to the council. What is important to the board is that the program director on these categories of decisions, before they act, gets approval from the board. If that delays something, and if there's so for your example, Mr. Iceland, the board can always call an emergency meeting. That's within their right under the public meetings law. In an emergency situation like what you're describing, the board would call an emergency meeting consistent with the open meetings law, have the program director, whether it's Mr. Schaff or someone in the future, come, explain the emergency, and in that meeting, they would adopt that. So that's, again, I think the key concern the board has is that the program director, whoever they may be, and we hope Mr. Schaff is here with us for a while. I know he just got here, so presumably he will be. But this is for longevity, Mr. Iceland. Someday Mr. Schaff will like to retire, I'm sure, from public service, and there will be another program director. This is needed to really, until we can amend the local law, which again, Mr. Eisen will be coming to the council to do to clarify this. The board's concern is that it is clear that these decisions are not made until they give their approval. And if there's an emergency, they will hold an emergency meeting. There's plenty of ways under the open meetings laws they can be addressed. And again, this decision to amend these bylaws is solely within the authority of this board.
So, and again, I cannot give you a statement on, official opinion on whether these comply with local law D because of the waiving of the normal time frame. You know, I was expecting to come in and not just discuss these, and I was gonna look at them, but now that we're actually moving on them, I do have to bring these serious issues to your attention and to the attention of the council.
Sure, and again, we're moving on them consistent with the rules of procedure. Rule 11 was just followed to the T. Rule 11 allows what the board just did. It was a unanimous vote of six members on waiving the normal process, which is allowed by these rules. So I hope you understand that was done consistent with these rules.
Right, and you know, the program director is a very highly paid position for the city of Albany. I think that with the remaining responsibilities, which I'm still waiting for, I don't think that they will be, that it's a position that, you know, it earns that much of a salary grade. I think that the position that you're really asking for is a press secretary and administrative assistant.
I'm not sure I understand your comment. Can you clarify?
Never mind, it's fine.
No, I'd like you to clarify that comment. What do you mean?
I clarify that as you said, you stated that there are a world of examples of activities that they could still do besides official communications. I have not seen any. I know that we really respect the work that the CPRB does. We've made program director a very high city grade position on this, similar to the city clerk. You know, this is a person who's expected to act with autonomy, discretion, to do things to make the CPRB a day-to-day functionary where, you know, you guys have day jobs and have very important things. I truly believe that this will hamstring the CPRB in violation of local law D, and I will be sharing that with the council, but I understand, as Kevin said, that the CPRB is free to enact the rules of procedure as they see fit.
Right, and
what that might mean in the future, we'll continue to have discussions.
And Mr. Eisen, I just want to clarify, I think something that's being sort of lost here. Number one, I haven't heard how you believe that this amendment on official communications will completely hamper the program director, as you're sort of saying. It's not clear. But more importantly, all these bylaw amendments do is create a structure so that in this limited world, these 6 items, which leaves, by the way, the entire other world that are not mentioned, these bylaws open for the program director to act. In this limited world of 6 amendments, the board has spoken to myself and Mr. Goldstein and made clear, given the last 5 months, there's a need for clarity on these 5 items, which these 5 items are the most, they most directly impact the proper operation of the board, and it is vital to the board that these decisions are only made with their approval, and that's well within their power.
Well, the last thing I'll say then, I understand the desire for additional clarity, but I truly feel that no one has learned anything from our conversation right now.
I disagree. I think they have. If you have not, please tell us what you don't understand.
I don't understand what responsibilities the program director will still have once they cannot make official communications.
Just for a clarifying
Not
point.
sure I understand your point.
All right, just for a clarifying point, and this might help everybody out. So with regards, we're looking to post various roles, investigation, and we have investigation committee meeting next week to put forward our proposal to post for a position.
A post for a position that's public, that could be a communication.
It's okay, I'm talking to Kevin.
What did you just, Jake, I didn't.
No, it's okay, and I wasn't trying to cut you off. I'm just saying, in my interpretations, that wouldn't be official communication. It would just be us posting to the clerk's office. Kevin, can you clarify if that would be considered a communication if it's something we're talking about and requesting to put forward at a committee meeting rather than having the whole board vote on it?
Can you, might be just my hearing. Which piece were you asking about?
I'm saying we're looking to post or put the post out for to the civil service department for, let's say, investigators or senior
Yes.
investigators. Would we have to bring that to a meeting to vote, or could we, if the investigation committee reviews it, talks about it, gives it to our program director to post, would it be possible to post without having to vote on it? Would that
Yeah,
be-
yeah, I
Okay,
think
that
so.
wouldn't be considered official communication because it's not necessarily speaking out to the public, but it's something internal within the city.
Correct, yeah, so that I think is a good example. Certainly, even in that example, I will come back to, because it's relevant to everything we're discussing, anything the program director is doing always should happen at the direction of the board. That's clear in the statute, and I think everybody agrees on that. In that instance, I think you could allow it through an investigation committee. I think an official communication would be a letter that goes out to the public, a letter that goes to elected officials.
That was what I said would be an official statement. I feel like that's the difference between a
So
statement and a communication.
you're making an issue over the word communication versus
Yes.
statement?
Because a communication can be a phone call, it can be, asking.
Well, I mean, assuming, I assume what you're saying is that change alleviates the the common council's concern. Is that your position?
I believe that changing communications to statement would absolutely alleviate a lot of my concerns.
I mean, frankly, my recommendation of the board would be, and we can do it here tonight, it would just be a motion to amend subdivision 1, or excuse me, subdivision 5, to change that to statement, to change that word from communication to statement.
Yeah, and then the other recommendations I would have is if we could add more specificity to modifications, because I really do believe that modifications would.
So Mr. Iceland, we can always amend these bylaws again. This is not the end of the discussion. We can amend them tonight, and then the next month, the board can amend them again. This is not the end of the discussion, so
Right.
I understand you have some concerns. If the board wants to change that word from communication to statement, I think that would be fine. But I don't think we're in a position to, the board put a lot of thought into these changes. If you have additional things once this passes tonight that you'd like to see changed, the board can certainly meet again as quickly as next month and make another amendment. So that nothing should be delayed tonight because of a question over verbiage as to something minimal like communication versus statement.
So, look, I come from the perspective of both the state legislature and the common council, where all legislation is introduced in age unless you get a message of necessity. You have to say the reason for the emergency,
And
often like a letter from the governor. So
Yeah.
that's.
Mr. Iceland, the
where I
chair
come from.
just did that consistent with Rule 11, the chair just did exactly what you said.
Sorry, and I missed the reasoning for the emergency. I apologize.
To ensure uninterrupted operations of the board in light of the new structure. That was clearly stated by the chair, consistent with Rule 11. And
All
sir-
right, I'm not sure I agree with that
Well,
being
sir, this
emergency,
isn't,
but I understand that.
sir, this isn't the state.
I'm going to jump in here. I think the clarification that was needed, John provided, because originally you
Yep.
mentioned communication in context to talking about email communication from another department head.
Yeah.
It could be admin services, the commissioner there, it could be myself, it could be HR director.
Yeah.
I think that's where the misunderstanding was. So when John, when you further explained it, that's where, that's the response that we were looking for, because we don't want to put in anything in the bylaws or anything in a job description that's going to hinder the programs director's ability to do their job duties. The way you
Certainly.
explained it, it hindered that, and that's what we don't want.
I disagree with you, ma'am, but I think now that it's clarified, there may be no need
Fine. It's- yeah,
whatsoever.
It's okay that you disagree, but I just want to make sure that it's on
Yeah.
record that any communication could be an email, it could be an HR situation that he has to deal with
Yeah.
personally.
I think I made that
It could be an email
clear.
directive from, admin services given to all department heads or any city official, city employee. We don't want there to be a delay in a response. And that's where I think your response to Jake's question, that's where the
So-
little issue was in regards to understanding.
Yeah.
So when John explained it, that was a better explanation, so we can clarify that.
So I'm very happy that now that John's weighed in, everybody understands, and Mr. Iceland, your concerns are then settled.
Yes,
Great.
thank you.
So then no need for an amendment there. Okay.
Well, no, my concern would be that there'd need to be an amendment from from communications to statements. Without that
So-
change, my concerns would not be addressed.
So what I would recommend, Mr. Iceland, is you prepare a formal set of what you'd like to see concerned. The board will vote tonight, and if they receive your statement and see the merit to it, they can easily have another vote to amend again. Sound make sense?
No, I think it deeply handcuffs the CPRB, and it could affect, and that could reflect on the council. But as I said before, I have not had time to give the full review that significant changes like this deserve because of the emergency, so I will.
For the record,
do
how
what I need to
long
do
is
in the
it
future.
going to take you to do that? We would like you to commit to a time frame, given how serious the concerns the board has had over this. Give us a timeline that you're going to provide that.
I would certainly have whatever review ready for the next meeting, as would be the proper time frame. But I
We'd
understand
like
that
it
you
much quicker than that,
announced
sir.
that it's an emergency.
So, sir, the emergency's been announced. We need your statement much quicker than a month from now.
Well, I understand, but that is an unrealistic demand of the council.
Sir, I think we're going to have to move on to preserve the board's time here. If you can't get a response in less than a month, that's a different issue we're going to have to discuss.
I can certainly get a response in less than a month, but the board will not be able to do anything about it until that meeting.
Not true. They can hold an emergency meeting.
Well, then we will do what we can to get you a response. as
Sir,
quickly
the
as
public
possible, but
officers law allows this board and any public body to hold an emergency meeting if there's emergency, based on proper notice requirements that can be done, and you've seen it many times in the council. So the idea that we have to wait month to month is just incorrect.
You can, but that is why I gave you the specific concern that I think is absolutely like a red flag, with the acknowledgement that I have not had the time to fully review other potential concerns.
So we'd request you move swiftly to do that.
Sure, but I will say I have done it for this specific concern, and I truly believe that it is a issue.
Let's now move on to your last concern, the 6th. You've already said you don't have an issue with termination and implementation. Your only concern is modification. Is that correct?
Yes.
Okay.
I think that, and it doesn't really need to be much more beyond, specifying what sort of modifications might actually be, would be okay. I think that fixing.
So modification should be taken in its plain language.
Yes, I think
No bylaws, sir, should be a Byzantine document that is 180 pages. We expect the council, yourself, other attorneys looking at this will read these words, for their plain meaning. And modification is very well defined through many years of public bodies acting. So let's not overcomplicate things.
I think that it could cause difficulties, but as I said, these would just be
Well, sir, if you're-
difficulties, and it's up to the board.
Sir, any bylaws, can cause difficulties. If you're looking for problems, anyone can find problems. This is pretty well written. If you want to present the board quickly with your actual specific concerns, I'm sure the board will entertain it. But without specific written concerns from yourself on behalf of the council, we're not in a position to delay the vote on this.
Just a quick question on form. Would a change to statement be an amendment we could make tonight, or would that be something that we should wait and clarify?
That's up to the board. If the board wants to do that, they can, and that's very easily done tonight.
I'm comfortable with that. In this way, you could say we don't have to. So, are they going to It's the one with, it's just this. They have to send something for this. I just want to change that. They have to, yeah, because I want to.
And Mr. Iceland, the one thing I want to point out, the bylaw amendments were sent to you directly over a week ago. So these were not just put on your desk tonight. So let's be clear about that. This whole group, everyone present, received these bylaws 7 full days ago. The board has expressed to your common council their concerns and their motivation. Your common council was provided with these amendments 7 days ago. We did that so you'd have time to review and comment. If you don't have those comments ready, we'll accept them later, certainly, and the board will accept them later. But there's an imminent issue that needs to be addressed, and we've explained that to your leadership.
All right. Speaking with the chair, I'm going to make a motion that we adjust the amendment to bylaw 5 to say statement rather than communications.
Okay?
Can I get a second?
What did you say? I'm sorry, John.
Just
I
this
couldn't
one
hear.
word, from communications to,
Was seeking, I'm sorry.
just from communications to statements on 5. I still would like to see some clarity from Common Council for what their interpretation of modifications is before we change that, and so we could clarify it, so we could all be on the same page, because that was a little murky for me, but I do understand with regard to the situation of the word communications rather than statement. I'm comfortable with statement if my fellow board members are comfortable with statement over communications. I made a motion. I'm looking for a second with regards to that verbiage on the section 2, part 5.
To clarify modification,
No, that's a whole separate thing. Just the statement one.
to change it to statement.
Yes.
Okay. I'll second it. I'll second it.
All right, Dr. B seconds. All in favor? 5. Batman, how we doing? Batman's thumbs up. So no abstentions, no nays. So we'll adjust that one word to statement. But I would like, Jake, if you're able to just clarify what ideas you have be more appropriate in your feeling than modification, so we could kind of talk about it, and we could definitely bring that up in our August meeting. So.
Yeah, I think that a statement is a official position, official public position that the CPRB is putting out, and a communication is, small,
Yeah, no,
day-to-day.
we passed that,
That's
which
been
changed the
amended.
statement. That's fine. It's the with regards to the modification. If we can
Oh,
get
yeah,
that.
so, I'm happy to.
No, it's, can we just get that in writing, and we'll do it. Thank you very much. Appreciate your help.
So just as a parliamentary piece, if you're voting to approve the amended version of the bylaws, it would just be a motion to approve these bylaws proposals as amended tonight.
All right.
So I just got one question. I just want to make sure that the board, is everybody clear on what we're attempting to do? We made the one change of the official statement from communication to statement. Okay, so I just want to make sure everybody's on the same page.
Yeah, correct.
Okay, all right. Batman, do you have any questions?
No questions, just the understanding that communication statements, they can be vague and however we choose to define them, so I don't think this is going to be the last time that we define those words. But I am in favor of changing the word for now, if that makes it palatable for everybody, for sure.
Okay, great. Thank you very much. So do I have a motion to move to approve the proposed bylaws amendments?
Second.
All in favor?
Motion to approve.
All in favor?
Aye.
Batman's thumbs up.
Okay,
All right, motion passed. Thank you, guys.
all right. The motion is passed unanimously. Program Director Schaff, we will leave it to you to arrange these amendments and put these into the bylaws. If possible, we would like to have the new amendments incorporated within next week or so based upon your schedule. Please provide copies of the amended laws to each board member and on the public website. Thank you, everyone. Thank you, Kevin.
Will do, Madam Chair.
And that was the end of new business. I'd like to turn the agenda over to John to do the review of complaints.
Thank you, Chair. Women, where am I going? Sorry, guys. Just finding there we go. So we're reviewing complaints this evening. We have 7 on the docket right now. The first complaint, it's a complaint that I'm assigned, but it was monitored by T&M, and it is CC 2024-001. Julie, if you could report on that as monitor, and then we'll go to questions
Sure.
and from the board and from any complaint statements. Thank you.
Yes, and John, I don't know if you can see the chat, but there is a citizen that wanted to speak. I think she missed the beginning, so just so you see that in the chat, I don't want it to get lost in the shuffle.
All right, thank you for pointing that out. We'll try to amend that, we'll try to put that in after our, in reports.
Okay.
If the,
So, I'm going to talk about CC 2024-001. The complaint came in, which said that Mr. Harrison was arrested on or about September 11th, 2023, pursuant to a search incident to arrest. Public Officer Drago removed Mr. Harrison's wallet from his person and removed $500 from the wallet. The amount of money was not returned. It was not reported to the APD property report, and there was an attached property report. The body cameras were not provided to the defense. Additionally, upon being taken into custody, the police searched Mr. Harrison's residence without permission and without a warrant. No reports or discovery were provided related to this search. Mr. Harrison reported that $4,500 and the keys to a vehicle were missing from his residence following the officer's search of his apartment. The complaint was typed by the public defender, Ryan LaRose of the Albany County Public Defender's Office, then signed by the complainant. It was filed on January 11th, 2024. Detective Burns from OPS was assigned on February 20th, 24, and it was submitted for closing on January 29th, 2025. OPS provided a closing report, but I can't, there's no date on the closing report, so I can't ascertain the exact date, but I'm assuming it will be sometime obviously after the February 20th, the January 29th, 2025 date. Just to kind of go over the facts, the background somewhat, there were two sales of a quantity of narcotics, one in July 2023 in the area of Sherman and Lexington Avenue in the county of Albany, and that was for a quantity of fentanyl, and there was another sale on August 28th, the same area, Sherman Street and Lexington Avenue, and that was for a quantity of crack cocaine. Both sales were to a person known to the APD. On September 11th, there was a call that the complainant who lived at 315 Hudson, not the complainant, a person who lived at 315 Hudson Avenue called in that they were being burglarized and robbed in their apartment, that someone had come in with a semi-automatic handgun, and another person had come in with a pocket knife and tied them up and took a sum of currency from them. So the police responded to that location, and when they got to that location, it was a person with a weapon call. They were out in front. They called all the occupants to come out, with their hands up, which they did, on a bullhorn. And when they saw the complainant, they recognized him as the person that had been involved in these two prior sales. So while there was a complaint made for the burglary/robbery, the complainant was arrested for these two prior sales of fentanyl and crack cocaine. While they were outside, police officer Tagayas, he patted down the complainant and he removed some personal property. He takes the complainant's wallet. He could be seen putting it in his vest. He then takes the complainant to South Station along with police officer McGee. They escort the complainant to the detective unit. The detective, Detective Dragos told OPS that he was, in an official interview, that he was with the complainant for a period of time until patrol came and transported him to the station house, meaning he was on the scene outside. And he said he collected the complainant's personal property while he was in the interview room. He said that the Property included shoelaces, belts, whatever else the complainant had on him. He never took the complainant's wallet. He never removed any money from the complainant's wallet or had anything to do with any money of the complainant. So that same day, Officer Johnson appeared in court. Officer R. Johnson appeared in court to get a search warrant for 315 Hudson to look for anything related to the person with the weapon call. And one of the responding officers was Officer Drago, and he told OPS in his interview that while he had his body-worn camera on when they initially responded to 315 Hudson, he did not activate it when he participated in executing the search warrant at the complainant's residence. And he said because they have been told by their supervisors they are not to activate their cameras during search warrants for tactic reasons, and they have permission not to do that. So also no one from APD, and this was confirmed with OPS, that filed a return on the warrant, so it's not sure what, if any, property was recovered. Detective Anthony Scalise was also familiar with the complainant from the prior drug sales. He also had his body-worn camera on when they originally responded to the location, but he said that he thought another detective, John Reagan, removed the money from the complainant's wallet and it was placed with the complainant's personal property. He then, he said he told the complainant that the money was with his wallet and that it was $457. On January 1st, 2025, remember this took place in September, they were cleaning out the detectives' lockers in the Detective Bureau, and during the course of that cleaning, $457 in U.S. currency was found in an empty locker. Scalise then circled back to the complainant's case file and saw that the complainant had $457 when he was arrested, and then he gave the money to another detective, Michael Comismo, to voucher and prepare the paperwork, which was done, and the paperwork says that $450 was seized from the complainant and retained as drug proceeds. So that's kind of the background of what happened. Our findings were, we concur that there was a call and that the caller that someone was inside their apartment, which was at the bottom floor, 315 Hudson, and that two people were inside, one with a gun, one with a knife, and the complainant was identified as one of the perpetrators. We concur that APD responded to the location. When they got there, they confirmed that the complainant was someone that they recognized for 2 prior drug sales. He was arrested for the sale of narcotics. He was transferred to the precinct. Prior to that, Togayas did remove the complainant's wallet. It was placed in his vest. Once inside the station house, there's no body-worn camera for Togayas. Someone else says that Reagan removed the complainant's money and placed it in the complainant's personal property. And then, which might be just a mistake, I'm not sure, in the confidential report, there's a finding that Detective Abrams seized the complainant's wallet and no paper was completed. I'm really not sure where that comes from, but it does say Abrams is no longer employed by the APD. There was no finding regarding the handling of the complainant's wallet. But there's no other mention of Abrams in the case file. So there was with no nexus between Detective Abrams and the arrest of the complainant, T&M strongly disagrees with OPS's finding that Detective Abrams was involved in the seizing of the complainant's wallet. No one at APD can account for who removed the money from the complainant's wallet and why it was not originally vouched as either arrest evidence or personal property. However, all the officers interviewed agreed that the complainant had a wallet with $457 when he was arrested and it was removed from him. After a locker cleanup, that money, $457, was recovered in the CIU. Scalise did check that the complainant had that money in the time of his arrest, so he gave that to Comismo to be vouchered. I'm not really sure why it's vouchered as proceeds from drug sales, however. The search warrant was sworn by R. Johnson, and he told the court that a safety sweep of the complainant's residence was conducted, and they observed significant drug paraphernalia, a white chunky substance with crack cocaine. search warrant was issued. The complainant alleges that $4,500 and a key to his vehicle were recovered but not accounted for. Both Dragos and Scalise said they participated in the execution of the search warrant but did not activate their body-worn cameras, and they couldn't remember if anything was recovered from the complainant's residence. Scalise doesn't indicate in his interview if any property was recovered after the execution of the search warrant, nor was he asked. There's no information in the case file if any property was recovered after the execution of the search warrant. Both detectives told APS that the failure to activate their body-worn cameras was in the direction of their supervisor. There's nothing in the case file that OPS ever confirmed that policy with the CIU supervisor. The complainant alleges that this money and these car keys were taken. OPS failed to investigate this allegation. Of the officers interviewed by OPS, only Drago said anything related to the recovery of the complainant's property, and he couldn't remember if anything was recovered. OPS did not ask any of the other detectives that participated in the execution of the search warrant if any property was recovered, nor did they ask why there was no return on the warrant filed with the court. Moreover, OPS did not make any inquiry with the CIU or the district attorney to determine if any cash was seized pursuant to the search warrant, and if so, what was the disposition of that seizure case. Therefore, T&M cannot determine if the complainant's allegation that he was missing a substantial sum of money in his car keys is meritorious, because there's nothing in the case file, because OPS failed to investigate these allegations. OPS did not investigate the complainant's allegations regarding the failure to provide him with any reports related to his arrest for BCW, since it is not within APD's responsibility to do so. They're correct in not doing that. Rather, it's the district attorney is responsible for providing all discovery to a defendant after his or her arrest. So T&M agrees with OPS on this allegation. And T&M finds that the handling of the complainant's wallet and the money was incredibly sloppy and not in accordance with OPS's general orders. None of the officers had a clear understanding of who removed the complainant's wallet or what happened to it. Eventually, the money does turn up and it's vouchered as drug proceeds. Well, T&M finds that once the money was found, it was good that it was accounted for, but vouchering it as drug proceeds was incorrect. The complainant has alleged to have engaged in drug sales, one in July and the other of August of 2023. He's arrested in September of 2023. There's no nexus to the sale of drugs, since one was 2 months earlier and one was 1 month earlier. So, and the APD was responding to an unrelated allegation where it was alleged that the complainant burgled and robbed a neighbor, but the complainant was never arrested on these allegations. So the money recovered from the complainant was improperly vouchered as arrest evidence, and it should have been revouchered as personal property. The complainant alleged that a large sum of money was missing and searched from his residence. As I said, the officers who conducted the search warrant failed to activate their body-worn cameras and failed to file a return on the warrant with the court. Therefore, T&M cannot determine if any property was recovered based on the detective's actions. The officers claim they were directed by their supervisor not to activate their body-worn cameras. And I said earlier, OPS never confirmed if this was accurate. However, even if the officers did receive this directive, it is a direct violation of APD General Orders 3.215, body-worn cameras, which Roman numeral 2C reads as follows. All detectives and officers assigned to plainclothes patrols, including personnel assigned to DART, shall be required to utilize a body-worn camera while engaged in pre-planned interdiction activities, including search warrants. Emphasis supplied. The officers failed to activate their body-worn cameras, and OPS failed to address this on their confidential report. Johnson indicated in his sworn application for the search warrant that they saw drug paraphernalia and possible crack cocaine were observed at the complainant's residence, yet no property was vouchered after the execution of the search warrant, and they didn't file and Johnson did not file with the court a return on the warrant indicating what, if any, property was seized. As I keep saying, you can't determine if any property was recovered after the execution of the search warrant, since the officers failed to activate their body-worn cameras and failed to do the return on the warrant report and failed to file it with the court. I would note that the New York State Criminal Procedure Law 690-50 subsection 4 and 5 state, upon seizing property pursuant to a search warrant, a police officer must write and subscribe a receipt itemizing the property taken and containing the name of the court by which the warrant was issued. If property is taken from a person, such receipt must be given to a person. If property is taken from premises or a vehicle, such receipt must be given to the owner, tenant, or other person in possession, therefore if present, or if not, the officer must leave such a receipt in the premises or vehicle from which it was taken. And then subsection 5 is upon seizing property pursuant to a search warrant, a police officer must, without unnecessary delay, return to court the warrant and the property and must file therewith a written inventory of such property subscribed and sworn to by such officer. And that was not done. So our findings are as followed. For Officer Drago, arrest procedures, the finding is exonerated. For Officer Tagayas, evidence and property handling, it's sustained, that's concerning the wallet. For Officer Scalise, Detective Scalise, evidence and property handling, our finding is sustained. For Detective R. Johnson, the general call handling is sustained. For Drago, for Ann Scalise, for failure to activate body-worn cameras, that is sustained as well. For our finding.
Thank you very much, Julie.
Sorry, it was long.
Are there any questions from the board? I'm not sure if the complainant's online, if the complainant has...
Probably not. I think he's incarcerated.
Okay. So I'm assuming not, and nothing coming up on the computer. So I'm going to make a motion for these 5 findings. For the first finding, the allegations of arrest procedure as exonerated, I think a motion to accept that finding. Second, please.
Second.
All in favor of upholding the exonerated findings for arrest procedure? All right, I see a thumbs up on the screen for Batman. And then we have 3 calls for, two calls for property handling with regards to the wallet and money. We find these are sustained as the property wasn't directly handed over, and then the way it was categorized wouldn't be appropriate as per the general orders. So 2 findings for sustained for evidence handling, or property handling rather.
Second.
Second, can I get a vote? All in favor, Batman? Batman is good. So that's complete. Next is general call handling with regards to the warrant by Lieutenant Johnson. The finding is sustained with regards to the procedures for the warrant.
Second.
All findings? All right. Unanimous. Then the last one are body-worn camera. Failure to activate body-worn camera, and this is pursuant to the warrant, which is spelled out by the general orders. I make a motion to find sustained.
Second.
Second. All in favor? Batman, aye. That's unanimous as well. Thank you very much, Julie.
Hold on,
Oh,
hold on.
Actually,
hold on.
though,
Yeah, Julie, would you mind doing us a favor? It looks like you made some recommendations regarding
Yes.
this.
Thank
Would
you.
you mind going through those, please?
right, so since it's not timely for discipline, however, we recommend that Scalise and Commissioner be retrained in general orders 2.1, property and evidence control and general orders, 5.220, central booking prisoner processing, that Detective Drago and Scalise should be retrained in general orders 3.215, body-worn cameras, that Detective R. Johnson should be retrained in New York Criminal Procedure Law 690, search warrants, and all of the supervisors in the criminal investigative unit should be retrained in general orders 3.215, body-worn cameras.
Great, thank you.
All right. Thank you very much.
Thank you.
All right. Now I'd like to call up Mr. Lawrence up to the dais up there, please.
Good evening.
All right, and I don't have my sheet in front of me. Which the first one, please, Lawrence? I think it's yours.
Yes.
So can you read the number out for me? I'm sorry.
This is CC 2021-025.
Yes, I believe that I presented this in October or November, and I thank the board. I don't have the minutes, but I think the board disposed of the allegations, but there was a question that I don't remember,
So
perhaps of Detective Vidalian.
yes, the question was, Detective, so we got a response from APD, and Detective Vidalian has attempted to follow up with Mr. Anderson's attorney on several occasions in attempt to get photos. Mr. Anderson, the photos that Mr. Anderson had mentioned that evening, to which he received no response. As far as Mr. Anderson's funds, they reached out to the unit supervisor to confirm if Mr. Anderson picked up his money. He had, and on a chain of custody report, that Detective Mulligan returned the money to Mr. Anderson in the form of a check on 11/20/2024 at 1:36 p.m. And that report is per Detective Lieutenant Riddy. So I believe this is that the gentleman had received his funds and it was already recorded. Detective Lieutenant Riddy, would you like to make any kind of statement? Thank you for providing this information also.
No, there's nothing further from the Office of Professional Standards on that. There's been no new news on that, so the last bit of information that we discussed with you is the most recent.
Perfect. Thank you very much. Thank you.
Okay. And I believe the next one on the docket would be CC 2022-012. And that's with Batman. But Ms. Lawrence, could you speak to that? There's 3 findings for that.
Yes. In this matter, the complainant alleged that the police used excessive force in arresting him during a drug raid, and that they improperly pointed an AR-15 at him, improperly searched him, that they denied prompt medical attention for an injury that he suffered during his arrest, and that while he was being treated at the hospital for that injury, an officer told the complainant that the officer had slept with the complainant's girlfriend. The complainant said that he was looking at potential lodging at an apartment on Broad Street in 2021 when the police arrived and busted down a door and drew weapons. And the police records and statements of the arresting detectives indicate that they encountered the complainant during a court-authorized raid, and that the complainant was struck in the head, arms, torso with a ballistic shield when he didn't comply with orders to get on the floor. He suffered, according to the police reports, a small cut to his forehead and was treated at the scene by a detective sergeant and eventually taken to the hospital. Hospital records that the complainant furnished with his complaint indicated that he was given stitches to a cut on his forehead and that a CT scan showed no concerning findings. He was arrested on a number of drug charges. The body camera footage of 4 detectives involved in the raid is brief, but it does show that one detective by the name of Kromzak was holding a gun over his shoulder, but you can't really view and determine at whom it is pointed. The detective handcuffed the complainant and told him that he has got to listen better, which would seem to indicate that he wasn't complying with the officers. The detective denied in his interview with OPS that anyone had pointed an AR-15 at the complainant's head. And a report by another detective does acknowledge that he was given a visual body cavity search with negative findings on the authorization of a sergeant. And finally, an officer who accompanied the complainant to the hospital acknowledged having a casual conversation with the complainant, but insisted that he does not know the complainant's girlfriend and did not say that he had sex with her. Two of the detectives that were on the scene have left the force and could not be interviewed, but their body camera footage was obtained and reviewed, and the investigation of the complaint, I think, was as thorough as possible. Concerning the substance of the complaints, the detective, Kromzak, has conceded that he struck the complainant with his shield in order to get him to comply with his commands. And officers can be heard on body cameras to tell the complainant that he didn't listen, although it's not possible to see whether he was complying or not at the level of resistance or the level of resistance that he posed. In any event, his injury didn't appear serious. It could not be detected from body camera footage, and no blood was apparent at the scene. As I mentioned, the hospital records do indicate that stitches were required to close the wound. Since it's not clear whether the complainant offered any resistance requiring the use of force, I would conclude that this allegation is not sustained, rather than that the officers, or specifically the detective, Kromzak, was exonerated, as I believe is what OPS recommended. The body camera footage does show that a gun was being pointed into the room where the complainant was being apprehended, but this would not seem an unreasonable use of force in subduing a suspect and protecting the safety of the officers involved. So I would find that the officers were exonerated on that allegation. One of the detectives has, as I mentioned, acknowledged conducting a strip search, but this doesn't appear unreasonable as the result of an arrest in which narcotics and a weapon were uncovered. So I think that the officer should be exonerated on that allegation as well. The complainant alleges that he was denied medical attention, and the detectives have maintained that a detective sergeant administered first aid on the scene, and one of the body cameras does depict a scene in which it appears possible that the sergeant is doing that, although his body is in front of the complainant, so it's difficult to be certain what he's doing. It can't be determined from the body camera footage when the complainant asked for treatment. He was taken to the hospital about an hour and 45 minutes after his apprehension, which doesn't seem an undue delay for what appears to have been a minor injury. So I would conclude that the officers were exonerated on that allegation as well. And the final allegation concerns a remark about the complainant's girlfriend that he claims was made at the hospital. The officer assigned to guard him there vehemently denied making such a remark, but there's no body camera footage available to confirm or deny that claim, so I would find that that allegation is not sustained.
All right. Yeah. Batman, would you like to comment? If not, I could ask the board for any questions related to this this case.
Yeah, it was one question actually I had for APD when it comes to the strip search part. Is that standard in a raid? At what point, what action is the catalyst to trigger a strip search in situations?
Lieutenant Riddy, did you hear that question?
Yes, I did. It's a multitude of different factors on that. We're looking through the case file right now just to see if it's been addressed within there. But really, if there's enough articulable reason to conduct a strip search, at that point it would be authorized to conduct one. So, again, without going through the specifics of the case file at this very moment, I would say that it's not unreasonable in these situations with the raids. Again, it's depending on what the raid is for, what the search warrant is for, and what the scope of their investigation is, and what they believe could be created on or within the person. So that's ultimately the purpose of the strip search.
And the searching officer noted that it was his sergeant that gave authorization. Is that usually standard? Is it a sergeant that usually gives authorization with regards to a search like that?
Yes, it's got to get the approval from the sergeant. There's an APD form that's also completed as a result of that. So I'm just looking it over right now. So within the confidential, it says strip search was approved by Detective Sergeant Wood due to the nature of the search warrant to ensure the target did not hide any drugs or weapons on or about his person. And then the appropriate paperwork for that was completed. So I can't say whether or not it's 100% standard across the board for every search warrant that's done, but there's got to be a specific and articulable reason for that. And at that point, it's up to the discretion of the detectives and the detective sergeant to authorize it.
Thank you, Lieutenant.
So conceivably, it could be a low threshold of if we're looking for drugs, he might have drugs on him. Therefore, it could be warranted. And I hear what you're saying, and I understand that's going to change in situation. The only other change I had from the monitor's report was on the question about if the gun was pointed at the gentleman. I just wanted to move to not sustained instead of exonerated on that, based on the lack of video evidence that could provide a comprehensive account of the events. I'd just rather move that one to not sustained as well.
Going back to Mr. Lawrence, are you comfortable with that as a not sustained rather than exonerated?
Sure.
All right. Is the complainant here by any chance? Not seeing anyone. Is that all the questions from the board? I'll go through the 5 findings. First, with use of excessive force, we find not sustained as we could not ascertain the evidence provided that the force itself was not undue. Can I get a second for that first finding of not sustained? All right, all voting in favor of this not sustained verdict? Batman, you're good with that?
Yeah.
All right, Batman's in
Member
approval.
persons, can you please announce your vote?
Oh, sorry.
No, Mr. Victor Persons,
Are you agreeing?
your vote in this matter?
Do you agree with not sustained? Yes. Okay, thank you. And then amend to our report, but the second allegation of excessive force with regards to the assault rifle, we're going to put not sustained as it was seemed to be not clear as to how it was positioned, and the relationship was it to the actions. I'm making a motion for the second finding as not sustained. Second, Dr. V. All in favor? Aye. Thank you, Doctor. Thank you, Batman. All right, everyone's raising their hand. Unanimous. Third allegation: improbable conduct of strip search. And thank you, Lieutenant, for helping us clarify that. We're going to put exonerated for that finding of 3. Can I get a second for that motion? Second. Thank you very much. And all in favor of exonerated? Aye. Very good. Fourth finding: denied medical attention. We heard from Dr. Lawrence in the video evidence. The complainant was seen to by a detective sergeant and then later taken to the hospital. This is going to be exonerated as well for finding number 4. Can I get a second for exonerated?
Second.
Thank you. All in favor? No opposed? No abstentions? Thank you. The next finding was an officer improper communication with the complainant with regards to a relationship with his girlfriend. This is going to be not sustained or not able to be, this is not sustained just because we did not see any evidence of this, and the officer denied it without any substance. So this is not sustained as well, finding number 5. Can I get a second for that? Second. Thank you very much. All in favor? Aye. All right, ayes all around, it's unanimous. Thank you very much for, Dr. Lawrence, Ms. Lawrence, for this one. We're going to move on, if that's anything further with regards to that. We're going to move on to CC 2023-0-53.
Okay, on June 20th, 2023, the police were called by a man who reported an odor coming from his neighbor's apartment. And 2 officers by the name of Tarosky and Geske responded and met the caller and the caller's friend outside the apartment. The friend was also the sister of the occupant of the apartment. The officers got no response when they knocked on the door, and they found it unlocked and entered and found a body lying face down on some bedding on the floor, and this is evidence from the body cameras. They returned to the street and reported their findings to the couple on the street, and were told by the deceased sister that the man liked to drink and use drugs. The man who called the police reported that he had seen the deceased man enter the apartment with a woman several days earlier and asked the police whether they could check cameras around the building, but Officer Geske replied that there were no cameras on the scene. Officer Tarosky then consulted a sergeant who advised the officers to do a thorough search of the premises and to hold the scene until a coroner arrived, and that if the coroner found anything, they should notify the sergeant, and he would summon detectives. The officers then searched the apartment and found some items that they believed are used commonly in narcotic consumption. The coroner and an assistant then arrived with a stretcher, came into the apartment, and as the coroner surveyed the scene, he made the remark that he thought the body had been moved post-mortem because of its position on the floor. The man, he said, would have had to have been standing against the wall when he fell face down in the position that he was at. And he said, I think somebody put him like this. Somebody moved him. I'm not saying they killed him, the coroner declared. In an interview during the investigation of this with Detective Burns of OPS, the coroner only referred to this as an offhand comment that was mere speculation, kind of downplayed it at that point.
And just that was the coroner saying that it was a speculation, right? Just
right. Yeah. So again, back at the scene now, the assistant sort of hastily placed the body in a bag, and he and the coroner put it on a stretcher, carried it out of the apartment, and loaded it into a vehicle, and the assistant drove away. And the 2 officers then left the building and returned to the street. Then the sergeant arrived, and the coroner again reasserted his belief that the body had been moved. And the sergeant declared, this sort of changes it for us. And he told Officer Tarosky that when he was told that the body might have been moved, at that point, everything should have been held. In his interview with Detective Burns, Officer Tarosky acknowledged that he probably should have prevented the coroner from removing the body and should have viewed it as a possible crime scene, but he didn't do so because he and Officer Geske did not consider the death suspicious at all. An autopsy did later confirm that the death was caused by cardiac failure due to ingestion of cocaine and fentanyl. The complainant in this case was another brother of the deceased man, but he was not on the scene and had no interaction with the investigating officers. He alleged that his brother's death was not properly investigated, and he said that the police should have interviewed the neighbor and the sister, whom he characterized as having gross intentions, whatever that means, and he accused the neighbor of hiding out with the sister in her apartment in Schenectady for several days before they discovered the body. And the police should have examined the camera footage the complainant alleged. So the investigation, I think, was by OPS was thorough and competent, and I would make the following conclusions concerning the allegations. The officers did question the neighbor and the sister concerning their knowledge of the situation, and I think they should be exonerated on the allegation that they did not do so, inasmuch as there was no evidence that the death was caused by anything other than a drug overdose. The officers determined that there was no camera surveillance of the area and should be exonerated on that allegation as well. Officer Turowski did fail to preserve the crime scene, or a possible crime scene, by allowing the body to be removed in violation of a general order that requires that all sudden deaths be considered homicides until proven otherwise. And he failed to preserve the crime scene by leaving his post and returning to the street once the body had been removed by the coroner and his assistant from the apartment. He was also insubordinate by failing to comply with the sergeant's order to preserve the scene if the coroner raises anything, again in violation of department general orders.
All right, thank you very much, Mr. Lawrence. So we have 5 findings here. I'll go through them one at a time. Failure to properly investigate was the first finding, and that is exonerated. APD, the detectives, did their due diligence, so we're finding first finding of. Oh, I apologize. Thank you. I had myself. Is there a complainant present? I do apologize. And any questions from the board? I'm sorry again. All right. Seeing none, we'll go to. Hello. Any questions, Batman?
Yeah, sorry.
Sorry about that. I'm sorry about that. I jumped the gun.
No, no worries, no worries. My reception is spotty, I'm sorry. The question of exonerated as far as the investigation process goes, with there being a failure to preserve the crime scene and it's supposed to be treated as a homicide and it wasn't initially, would it also be fair to say that the questions asked of the neighbor and the sister and other people, they weren't questions as they pertain to a homicide investigation, they were something of a different nature, is what I'll say. So if that's the case, correct me if I'm wrong.
No, so we do have findings related to the crime scene itself by the officer that was responsible for that, but the actual affection of the done by the detectives with regards to doing what they had to do with regards to the findings, we found that. And this was assigned to me as well. We found that the detectives themselves did the job that they were supposed to do. It was rather the officer that was in charge of preserving the crime scene and following the orders of the sergeant with regards to the body. Was the person that was in poor finding, not necessarily the detectives who were pursuing it with the knowledge they had at the time.
Gotcha. Okay, understood.
Okay. So yeah, we have there's 5 findings here. The first is regards to investigating the death itself, and we found the first finding for that is exonerated. Can I get a second for that? Or any questions related to that specific complaint?
Can you say that one again?
So, police failed to properly investigate the death by neglecting questioning the 2 individuals that were there at the time. And what we found was they did talk to those individuals.
Detective Lieutenant Reddy?
Yes. I'm sorry, I don't know if someone was posed. I don't know if the audio was kicking out or not, but.
No worries, no worries. I just got a question. Is it common for, because I think it appears that the family was opposed to the case being closed on the same day, is that right? Because I don't have the actual complaint here.
If I remember correctly, it was one brother that was, it wasn't necessarily the entire family with regards to the complaint.
Okay.
And it, from what I saw and looking at Mr. Lawrence's work, it wasn't, the case wasn't closed too rapidly. It was when they did have questions with regards to the crime scene, with regards to the position of the body, they adjusted their investigation to further that, and that was more on the coroner rather than the detectives themselves. So a lot of the evidence with regards to this is questioning of the coroner's interaction, and we don't have jurisdiction over the coroners. Okay. With regards to this, is specifically the complaint was they didn't talk to certain witnesses or available people, and they did talk to those people.
And remember,
Did you
these
understand the question?
these are patrol officers that questioning the people out on the street. They're not detectives investigating. So they're just the patrol officers who responded to the call of an odor emanating from the apartment. So they're not, they're not investigating a crime. They're just trying to figure out what the situation is.
Right. Okay, thank you.
And even just to help to clarify to Detective Riddy, with regards to a unattended death, what's the initial protocol to help clarify for the board?
So the initial protocol, really, like at its base, is you treat every unattended death as if it's suspicious in some manner. So you treat it as a crime scene, and then based on the investigation, as you process that scene, if it turns out that it's very apparent that it's natural causes or something else like that, and if the coroner's recommendation is in line, then you can kind of release it down from the crime scene aspect. But at the very base, you treat every single, we call them Code 35s or unintended deaths, as a crime scene.
And again, the police did talk to the individuals in question, so that's why it's exonerated.
Okay, all right.
All right. Second
So
on
I'll
the findings?
second. I'll second.
It's okay. And again, you could always say no or abstentions as well. So we have a second. Is everyone in favor of the exonerated with regards to questioning these individuals? Batman, how you doing?
Yeah, I'm okay.
Okay. Are you gonna no or abstain or yes? I'm sorry, I didn't hear that.
It was a yes, I'm sorry.
Okay, thank you very much. No, I appreciate it. All right, so unanimous on that. Allegation 2, police failed to properly investigate the death fell by examining camera footage. This was exonerated as well because the follow-up footage, right? Could you just clarify on that with regards to failing to investigate with regards to footage? Was it, with the investigators did do the process by getting this footage, that's why it's exonerated?
I'm sorry, John, I
The
couldn't hear
allegation
the end
number
of
two-
your...
oh, sorry. Yeah, I apologize. So allegation 2, police failed to properly investigate the death by failing to examine camera footage. And this finding we also found exonerated, correct?
Yes.
Okay, they did so. Any questions with regard to the camera footage that in question? All right, motion to accept exonerated? Second, all in favor? Batman, thumbs up? Thumbs up, all right. Unanimous?
I guess my question is, and I know it's kind of late in the game.
No, it's
but
okay.
even if it says, as soon as you find the body, you know, we're treating it as a crime scene, wouldn't that warrant a higher level of investigation, even from the cops who are there on site, as far as how they treated it, what questions they asked, and everything else, you know what I mean?
Well, that goes to the third, I think that goes to the third, where we found sustained, where the officer did not preserve the crime scene appropriately, rather than questioning. That's the next allegation. The officer did not preserve a crime scene on allowing the removal of the body after the coroner expressed suspicions with regards to the death. Does that, because that's the third charge.
I mean, that's, you know, the officer not preserving the crime scene, 100%, that's definitely on him. I get that part. My question is, again, if in general, unresponsive body, we don't know the cause of death, treated as a crime scene immediately, it just seems to me that that would warrant additional actions across the board. But again, as far as what they had at their disposal at the time, I hear you. So I'm moving forward, and I'm voting yes on things. But I do have questions just about how that process.
That's fine, and I think that's more going to be in Lieutenant Ritty's. Can you just elaborate a bit more again on procedure with regards to officers securing a crime scene and what's necessary when you have an unattended death? I understand you said you start at the highest tier and then work your way down. What might have something worked down or sustained? Lieutenant, if you could just give a little more information, I think might help Batman understand a bit better.
Yeah, I'll do my best to try to clarify. It's kind of hard with, given, you know, we're painting unattended deaths with a broad brush here, because each one is unique in its own way. So like I said, you treat each one as a potential crime scene. So you remove everybody from the immediate area. You investigate what's going on. So you look at the position of the individual. You look at anything surrounding them. You know, you don't touch them, you don't move them, but you see if there's anything apparent. So that's all part of the preliminary investigation phase of investigating unattended deaths. If there's something like drug paraphernalia around, if there's something like, say, some blood residue on something, as if maybe they fell and hit their head, and there's something that indicates as such, you know, that starts formulating the idea in your mind as to what could be a potential cause of death for this individual. And then from there, it's immediate, or not immediate, but once you get a good grasp, you try to ascertain the identity on the individual. You notify the supervisor. The supervisor should respond out, get eyes on the situation as well, and then from there, the notification of the coroner is made. From there, it kind of branches. So if there is, I'll back up. Before the notification of the coroner is made, it has the potential to branch off. So if there is something that is that looks like it could be foul play, drug related, something along those lines, then a notification should be made to our criminal investigations unit, and then from there it should be they can respond out in various different ways. A detective can respond out to take a look at the scene. Forensics could respond out. It really depends on the nature as to how the individual was found and what the circumstances are. If there is an indication that there's no immediate signs of foul play, then the supervisor will make contact with the coroner, and then the coroner comes out. It's communicated to the officers that once the coroner responds out, if there is something that changes, because again, keep in mind that there should be no interaction with the deceased. You shouldn't be moving them, you shouldn't be rolling them over, there should be nothing. Once the coroner comes and starts doing what he or she does, that's when the body will get ready to be removed out of whether it be a residence, establishment, whatever have you. That's when that happens. And if something at that point is deemed suspicious based off of what is now discovered, when that person is moved, or if the coroner has some sort of indication, again, you know, you might find some people face down and you can't see if there's any trauma to their face. Once all that is kind of uncovered and you can get a better look at the individual to see if there is anything that could be suspicious, that's where another pivot point in the preliminary investigation could happen. So if it's deemed there's nothing suspicious, then the person is deemed okay to go with the coroner, and then from there it can be scheduled that an autopsy can happen. If there's other circumstances where it was, you know, a stage 4 cancer patient who passed in the presence of somebody, you know, then it's up to the coroner's discretion if they want to release it directly to a funeral home or not. But that's getting into a completely different side topic. So there's a couple different pivot points in there where there's different levels of preliminary investigation need to happen, and there's multiple stages in which a pause in what's unfolding could happen as well, if that answers the question.
Yeah, I hear you. And I understand there's, you know, like you said, tiers to the questions being asked and things that trigger different things. And that's why, you know, the question of what was asked of the witnesses, the people who called in, being as they had a relationship to the deceased, and then the matter of cameras and due diligence, if initially unresponsive means it should have been treated as a crime scene or whatever, that seems to be the first catalyst that would, you know, enact different actions, as opposed to, like you said, somebody passed away in cancer in front of you, two different things. So once there's unresponsive, that would trigger that, and then combined with the coroner saying, this is where the body wouldn't fall like this, those two things wouldn't trigger additional conversations with the witnesses and additional search for camera footage in a more intensive way, I'm guessing. It just seems like the efforts to collect information and data were treated as general procedures as opposed to a homicide investigation, which would seem appropriate in this situation.
Well, yes, and that's where I would say that the latter portion of the investigation found that that's where the shortcomings were with the officer that responded out. Ultimately, and I'm not, you know, we have our findings and the CPRB is lodging their findings. But I think the way that it's broken up, there were several different portions of the allegations that were in there, and whereas there are portions in here in which there were failures, and those were called out and ultimately handled. So I think what the discrepancy is with this particular case is that it's the hang up of the police for the first allegation, the police failed to properly investigate the death by neglecting to question Mr. Jones concerning the gross intentions. Are we hung up on the police, which is the police department, including the detectives, or are we hung up on the responding officer? That's where I think the difference is, in which we're trying to gather right now. Because again, later on, it was found that there were failures by the responding officer, and there's no, our findings are in line with CPRB's findings that those are sustained. So I don't want to try to get too far ahead, because I know that those are, you know, that everyone's getting ready to present those. I hope that adds a little bit of clarity on that front.
No, that makes sense. And it makes sense that there's some things like, you know, failure to secure the scene as it was supposed to. Okay, cool. We all agree on that. Hey, that should have happened in a different way. So I'm just concerned with what other action should have happened differently, but I'll listen more. And I do understand different individuals who responded had different roles and different areas of focus and different questions that were their responsibility. So I'll listen more, but that's, I guess, in summation, kind of, that's my biggest issue is, did everyone's actions follow the unresponsive body potential homicide protocol in that way? But I'll listen more for more information as well.
All right, thank you, Batman. And I think...
Yeah, I'll turn it over to the CPRB from here.
Thank you very much, Lieutenant. Thank you, Batman, as well. I think the next three findings kind of go in line with, I think, the questions Batman had with regards to the investigation. There's the allegations that the officer failed to preserve the crime scene, and this was found as sustained. He did not follow proper protocol when he allowed the body to be extricated from the site. So the findings are sustained with this charge against this allegation against this officer. Do I have a second for sustained for not properly securing the site? Second. All in favor? Batman? Thumbs up, thank you.
Yep, thumbs up.
Got ya. All right, next is the officer failed again, failed to preserve the crime scene, not just by letting the body be released, but leaving the scene, the immediate scene, to the exterior of the building. We find sustained as well, and that was plain with the evidence that was shown. I have a sustained finding for, again, failed to preserve the crime scene by leaving. Do I have a second?
Second.
All right. All in favor? Unanimous again. All right. Allegation 5, the officer was insubordinate by failing to comply with the sergeant's directive to secure the crime scene. And again, it was clear this officer did not follow that protocol and disobeyed his commanding officer. We find sustained with regards to this allegation as well. Do I have a second for sustained?
Second.
All right, all in favor? All right, thank you, Batman. All right, in this case, oh, no, oh, he's got it, I'm sorry, thank you. And the monitor has recommendations, would you be able to read that? Your recommendations?
No.
Okay, so I'll read the recommendations on your report. Section 4-42.332B, the local law, B2 of the local law governing Albany Community Police Review Board requires monitors to report to board as conduct investigation. Law says such reports recommend additional witnesses' statements should be taken, additionally questions which should be answered, additionally documents evidence which should be reviewed, such as cited deficiencies, if any, of the investigations, including whether a number of witnesses were questioned by professional standards, the scope of the questions asked of them, and reviewed by the documents. I find no deficiencies in the witness questioning, in the questions asked of them or the documents obtained. The investigation, though, was thorough, complete, and professional. The actions here with regards to what was sustained was related to an officer on the scene. According to OPS, there was charges related to that officer's actions, and discipline was referred out. Next, we're going to go on to any other...
Quick question.
Yes, I was going to say, any other questions before I go? Go ahead.
Yeah, sorry. Discipline was referred out. What was the run with that? What did that look like?
Excuse me? I'm sorry. Can you say it one more time?
Saying, for the officer who would fail to secure and all the other fun stuff, said discipline was referred out. I'm wondering, what did those disciplinary actions look like? What was this?
Good question. Lieutenant, I don't have I think you got a referral from the chief, but I do not remember off my top of my head. Lieutenant, do you have that documentation in front of you by any chance?
I have that, he was issued.
Oh, I have actually, I'm sorry, I have it right here, actually. It says he was given written reprimand and docked 2 days leave. And the reprimand was handed out by Chief Hawkins, who was chief at the time. He did deny the charges and request arbitration. But it was he got a letter and was docked 2 days. All right, we good? Thank you, Batman. I should have put that out ahead of time. I appreciate you having that question. All right. If that's it, we'll move on to CC 2023-047.
Okay, the events at the heart of this complaint began on the evening before June 6, 2023, when the complainant was walking his dog and came upon a construction site at which workers were laying a white substance on the ground, they said later, to alleviate dust. The complainant apparently inquired and was told that the substance was not harmful to animals, but his dog began limping, he said, and the following morning he returned to the construction site and confronted the workers. They called police, claiming he was yelling and screaming and threatening them and acting irrational. He was ultimately arrested for disorderly conduct and owning or harboring an unlicensed dog. So the complainant's allegations are extensive, but I think they can best be looked at in 7 categories. One, the demeanor of the officers, physical abuse by the officers. 3, the failure to address his complaints against the construction workers and what he called a conspiracy to cover up hazardous environmental conditions. 4, improper detention and arrest. 5, discrimination. 6, that the officers did not seek medical attention for his dog. And 7, that he was forced to disrobe in front of a female officer when he was taken to the hospital. So, beginning with demeanor. The complainant alleged that he was harassed by the officers who used crude and profane language and made aspersions about his childhood, that they called him a drug addict and a criminal, and that they defamed him by repeating these claims to his neighbors. The body camera footage establishes that these claims are largely without merit. There's no evidence of the use of crude or foul language by any officer in dealing with the complainant. An officer by the name of Chappell did repeatedly address him as sir and tried to calm him and focus his complaints on his the danger to his dog that he was claiming. He did make an offhand remark that you've been lied to since you were a child, when the complainant claimed that the construction workers had lied to him. But I think that could only be reasonably construed as an attempt to get the complainant to focus on the serious concerns he had about the danger to his dog. Another officer, Cacchetti, attempted to get the details of the complainant's allegations against the construction workers, but she was rebuffed by the complainant because of a prior contact that he had with her, which he had found unsatisfactory. And she was especially patient with him as he reviled her repeatedly for the handling of the prior complaint. Another officer, McGee, stood by but eventually lost his patience and threatened the complainant with arrest, and used the tone and command to lock him up, and answered the complainant's when the complainant asked his name. Officer McGee responded, "You can get it on your arrest record." And I think this only fueled an already angry individual, and I would find that this violated the general order that provides that officers be tactful and control their tempers, be patient, and not engage in argumentative discussions. The same officer, Officer McGee, did report that he had learned that the complainant was wanted on a warrant in Schenectady, and asked at one point, "What narcotics did you take today?" And another officer who rode with the complainant to the hospital did ask about medications and diagnosis, but no officer explicitly accused the complainant of being a drug addict or a criminal. The body cameras do establish that a sergeant who was on the scene told a neighbor who volunteered to take the complainant's dog that the complainant might be under the influence. And again, such speculation seems to me to be unnecessary, and I would find that that was lacking in tact and discretion as required by the general order. And Officer Chappell, once he got to the hospital, did speak to a security guard and refer to the complainant as an asshole. So to that extent, I would find that Officers McGee, the sergeant, and Officer Chappell, the allegations concerning demeanor were sustained in that respect. In those respects, I guess I should say. So the complainant makes an allegation of excessive use of force, but it's unclear to me whether he means this in the usual sense of affecting an arrest, force in affecting an arrest, or whether he's referring to complaints that he made that he was placed in a hot car after he was arrested, where he couldn't breathe and was denied water, and was placed in handcuffs that caused him severe pain. In any event, the body camera footage shows that little physical force was used in placing him under arrest. He didn't resist. His phone was taken from him, and Officers McGee and another officer took an arm and handcuffed him behind his back. But there was no struggle or confrontation as he was walked to the patrol car and willingly got inside. He did poke his head out of the car at one point and complain about heat and an inability to breathe, but the doors and windows to the vehicle appear to be open during most of his confinement, and the officers on the scene during the investigation asserted that it was. He wasn't given water, but an ambulance was summoned when he complained of pain, and the handcuffs were adjusted by Officer Chappell when the complainant said he was uncomfortable because of those. So I would find the allegation as to physical abuse to be unfounded. Concerning his complaint that that the officers did not take his complaints against the construction workers. He did report an allegation of sexual harassment by a construction worker, that the construction worker asked him whether he would like to see the worker's penis. He claims that he was injured in a fall at the construction site. And more specifically, the complaint about the conspiracy of the police and the construction company to cover up environmental crimes. The body camera shows no evidence of him attempting to report to the police the complaint of sexual harassment. And as I mentioned, Officer Caccetti did attempt to hear the complainant's allegations against the construction company, but she desisted when the complainant refused to give identifying information and said that he would pursue the complaint himself without the help of the police. Officer Chappell spoke with the construction supervisor about the substance that had been laid on the ground that the complainant had objected to and said was toxic and harmful to his dog. But the supervisor assured Officer Chappell that it was harmless to dogs. And the officer attempted to get from the construction supervisor an electronic document so that he could relay it to the complainant in his email, but the complainant rejected that idea and said it would be too difficult for him to read on a small screen. I don't think that the patrol officers on the scene could be expected to be competent to analyze the substance about which the complainant was concerned, and they seem to have no reason to believe that they needed to acquaint themselves with procedures to do this or to notify other authorities to do so. So I would say there's no evidence to substantiate a conspiracy or a failure to address Mr. Baum's complaints against the construction company. As to the improper arrest allegation, Section 240(20) of the penal law describes disorderly conduct as, quite broadly, as an intent to cause public inconvenience, annoyance, or alarm, or create a risk of violent behavior or make unreasonable noise. And Officer McGee alleged in the arrest report that the man had caused public annoyance by making unreasonable noise and yelling at construction workers on the street and arousing neighbors. So the charge does not seem unreasonable. Given the construction supervisor's allegation that the complainant would not let up on abusive, aggressive, and threatening language. Also, the mental hygiene law allows police to detain and hospitalize for a psychiatric evaluation any person that they believe to be mentally ill or likely to endanger self or others. The complainant appeared to be angry, loud, uncooperative, and unfocused in dealing with the officers, and he pressed complaints against the construction company, but then refused to take information that the officers tried to get for him. Whether this indicated a mental illness or an indication of danger, I think is a judgment call, but I wouldn't say it's outside the realm of reason and should be considered to be misconduct for the police officers to detain him on that ground. So I would conclude that those allegations are unfounded. It is true, however, that Officer McGee did fail to file an incident report concerning his detention under the mental hygiene law, and that is a violation of a general order. In terms of the discrimination claim, the complainant said simply, they never would have done this to an old African, white, Hispanic, or Asian woman. And the officers have all denied that those factors played any role in his treatment, and there's really no evidence of it in the body cameras. Concerning the treatment of his dog, the officers asserted that they saw no harm to the dog, and the sergeant on the scene arranged for the dog to be cared for by a neighbor. And the complainant consented to this before he was taken to the hospital. He maintains that he was forced to do this under extreme duress and pain, and certainly being in the process of arrest caused some duress, but he did appear calm at the time and grateful for the arrangement that someone was going to take care of his dog and that it would not have to be impounded by animal control. And as to the final allegation, the disrobing before a female officer, the body camera footage shows that a female officer was standing outside the room where he was about to be examined, and that he lifted his shirt as she was there, but a door was then closed. She was not in the room and could not have witnessed any further disrobing. Thank you.
All right. Any questions from the board?
I have a question. Al, did you or John, John's your case, right? Yeah. Okay. Reviewed the records for the officers as to whether there was a pattern of behavior with any of these officers for what was complained about here?
That was on me. I did not look at the personnel file with regards to this, as most of them were exonerated, but that's on me.
So did I.
I'm not sure what you think about
I
that.
didn't check the personnel report. That was, I didn't do that.
That was my only question. Thank you.
No. Oh, I'm sorry, Batman, you have your hand up on.
Yeah, I'm wondering, when we're hearing some of the things, there's something where the complainant was called to, he'd been lied to all his life. Things like that are pretty inflammatory and not helpful in a given situation. I'm wondering, was there evidence of any de-escalation tactics involved? Because when we talk about repairing the relationship, repairing the relationship, these incidents are critical, and there are opportunities to show people that we're different. So I'm wondering what de-escalation tactics were used as opposed to the inflammatory language.
There was some inflammatory language with regards to this complaint, and that we have sustained findings on that note. But with regards to the office, there was a good amount of officers involved in this, and from what I saw, the majority of officers were were operating in a calm manner. Also, the sergeant did work pretty hard to find a spot for his dog and make sure the guy was consented with regards to that. We do find sustained with regards to certain aspects of the officers' interactions and languages, but with the good amount of officers on the scene, I would say most were interacting with the individual in a professional manner. And even the ones that didn't, had instances of not being professional, it wasn't right off the bat. They kind of got escalated as the situation went on.
And my other question is, he was arrested for disorderly conduct, and it was mentioned that the people at the work site said he was causing an annoyance. So I'm wondering, is public annoyance in particular, and this is for APD as well, is public annoyance why he was arrested?
This was a mental hygiene loss. This would be considered an emotionally disturbed individual. So the arrest itself, he was taken for an evaluation for the hospital.
I'd like to talk to the board about that more. This situation came up before where there was someone who was in a state of crisis and not 100% responsive to a conversation. They were labeled emotionally disturbed, and I had a very strong question about the threshold of that and what constitutes that. And I'm concerned about how flexible that's used when it's time to arrest somebody. I'd like to talk to everybody about that.
And again, with regards to taking an emotionally disturbed person into evaluation, that's not an arrest. That's a different procedure. Lieutenant Ritty, I know
even then, my question is what triggers that interaction, because if I can say you're emotionally disturbed because you're yelling, bro, everybody yells when they're calling the police, everybody's in a state of crisis. Yelling in and of itself cannot constitute a medical need and we're going to take you to the hospital. That can't be it. So I'm wondering, and I'd like to talk to everyone about this, where is that wand? What does that look like? How do we make that determination? Because this is a multiple times that this has come up, that's been used as a justification. And I want to make sure we're very clear on where that line is.
Lieutenant Ritty, could you kind of help give the definition? I know we talked about this before, and it's a definite thing we see often with regards to complaints and just things going on in the city. Could you talk about the classification for taking someone in for evaluation under the mental health law with regards to APD?
Yes, so I mean, in its simplest form, the 941 mental hygiene. In its simplest form, it's taking somebody in essentially against their will if they're deemed to be a danger to themselves or others based off of a plethora of different things. It's really hard to put a solid I'm not gonna say description, but like a solid definition on it, because there are verbal cues, there are nonverbal cues, there are proportional responses based off of questions that you may ask that you would anticipate somebody who is operating without any type of, whether it be influences under any substances, or if there's any mental illnesses or anything like that are ongoing, you'd expect to hear from somebody. So there's a lot of stuff that gets involved with 941 treatments. So it's kind of very hard to put an exact definition on that one. But in its simplest form, it's if the person is deemed to be a danger to themselves or others, based off of, again, all those verbal, nonverbal, emotional cues. There's a certain threshold that needs to be met in that regard. So it's not to be used, and it's not proportional if someone's yelling. There's got to be more to it to authorize that ultimate detention and removal and involuntary treatment up at a medical facility.
And also just looking at the footage, I want to add, like, the person did seem in distress and wasn't acting in a rational manner with regards to what the officers were saying. He was combative towards the construction workers who were just trying to do their job, and if he wasn't leaving the area, which he wasn't, it wasn't necessarily a safe area if the police let him around those construction workers any further. And that, looking at that situation that he was in, and we see this a lot, and mental health laws, they're probably more open than a lot of us would like to necessarily see and have, and I hope the officers, police feel this as well, that the vagueness puts a lot of responsibility on certain calls. But with regards to this individual, him being evaluated because he wasn't acting rationally at the time, or didn't present rationally, and was presenting as a threat to the civilians that were in that area, it wasn't unreasonable to assume he was going to hurt them if he wasn't removed from that situation. And that, with regards to him and having him evaluated rather than arrested, would have been a more, lack of a better term, a better solution than having another, giving a summons or having arrested or anything like that.
Yeah, no, that's not okay for me. I definitely want to speak about that more. And if that becomes, we have to, make a recommendation, change general orders or whatever that looks like. And to be clear, when it's specifically, even when it's Officer Chappell, this is not the first time that he's threatened someone with that. The last time it was somebody who was having an argument, she was yelling and screaming, wasn't listening to him, and he said, "Oh, you want to go to the hospital next?" That was the thing. So I'm very concerned that when people are upset in a state of distress, because the things you described could count for anybody. I've been outside yelling and screaming, I'm mad at somebody, and I'm not listening. Yeah. Oh, okay, you're not listening, you're posing a threat, you're going to the hospital. No, that can't be what it is. There has to be, and again, a trigger of something else. We're aware of his mental health condition from his previous capacities, or we have some other thing.
Yeah, and just again to bring the other case.
Qualified to say this is a mental health concern.
The other case you brought up, though, that woman was not taken in for evaluation, and we found that it was inappropriate that the officer made that reference toward her. So it goes to your point where it could be used inappropriately, but it's a different situation.
What I'm saying is, if he keeps doing this and this keeps becoming a blanket justification, we need to put some recommendations on more specificity of when that's actually triggered.
And that's definitely a good conversation to have, but with regards, again, it's a state law, and we could talk about, and we talked about with APD about maybe adjusting clarifications with general orders, but at the same time, it's a state law issue, and the vagueness is in the law. And I believe, Dr. V, I remember you were speaking recently with regards to mental health law. Could you,
yeah, Batman, I think
clear concern with regards to this.
I think that you're raising a few points here, and so for this isolated complaint here, I think that it's possible that there could be some recommendations if we looked at the officer's complaint here to see if there's a pattern of behavior, because I recognize the name too from previous complaints where this is raised. So I think that that's something we could discuss with OPS to go back and look at for recommendations. As it pertains to the mental hygiene law 941 that is at the officer's discretion, I think that further down, which John didn't get to, that's why, and I don't mean to skip ahead, John, I just want to,
No, go ahead.
You were getting to that point. A part of the issue that our monitor and John found here is that the individual was brought in on a 941, there was not follow-through as to what was supposed to happen based on the removal there, which that in itself is problematic because we don't have, which the monitor and John found, because in this specific case, we can't say whether or not, based on the removal, whether it was proper or improper. But I think globally, happy to discuss, as you know, I'm very familiar, there's 941 by the police officers, and then there's a different categorization for mental health professionals to also remove a person based on their training and belief that the person is not acting or is a danger to self or others. So let's make sure we follow up on that, and we could talk to OPS, but we can't really, honestly, truthfully blanket it. I think it has to be circumstance by circumstance, and in this particular incident, John has agreed that we should look at the officers who were complained about here for a pattern of behavior, as you brought up.
I just want to be clear that it was Officer McGee, not Officer Chappell, who ordered the detention, although we didn't fill out the proper paperwork. And that Officer Chappell was, throughout this, worked very hard to calm the complainant and to try to get him to state his complaints against the construction workers. He did make that comment that you've been lied to all your life, but I think that was maybe a misguided attempt, but that was an attempt to make the complainant realize that the lying, if that's what it was, wasn't the most serious thing. He was attempting to resolve the situation to some degree. So I don't think it was Chappell that was
And I think, to be clear, not just putting a focus on Chappell, given the allegations and what we're charged to do, that looking at the disciplinary record, at least for the board, you can correct me if I'm wrong, should have just been a part of this file in terms of thinking about what we may or may not recommend, whether it be training, et cetera. Is that fair to say, Chair?
That's fine. No, that's fair. That's funny. Is the complainant here today? No. I mean, the proposal, I'll go through exonerations, but I won't make recommendations with regards to this until I check that. But I would like to go through is that?
I think that we should consider that if we table it, would it change the finding, right? Which it probably wouldn't, right?
No.
But what it might do is have recommendations. That's what we don't know.
Well, we could,
Would you-
I was saying is, we could, if everyone's comfortable, the findings are definitely for this. I could hold off recommendations and then bring this up in August and just state recommendations related to the personnel report, and that was on me. I apologize.
Okay, yeah.
Is everyone comfortable with that? Okay. Oh, I'm sorry.
Yeah, I'm sorry, Mr. Vice Chair. If you can just speak a little louder.
So I'm moving to, we're not going to table this because the incident is not going to alter the findings, but we'll go through and vote on the findings, but I'm going to reserve making recommendations till the August meeting with regards to the findings. Is everyone comfortable with that? So we'll vote on this and have it cleared, but we will bring it up at the August meeting just to follow up. Cool, Batman? Thumbs up still hanging? Okay. All right. Any other questions? or comments, and Batman, I do appreciate your point with regards to mental health law. It is a big deal and a big issue, and it's not something we're gonna, we keep seeing and are gonna keep seeing. So with the first allegation was officers exhibited discourteous or poor demeanor with using rude, disrespectful, foul language, speaking to the complainant, making comments about his childhood, accusing him of being a criminal, a drug addict, defaming him before his neighbors. We find this sustained specifically for the statements made by Officer McGee with regards to lock him up, and then a response from Officer Chappell with telling a security guard that he was an asshole, and also stating you'll find out on your record. We'll find out on your record. Again, the statement, especially with Officer Chappell, that initially he was attempting to de-escalate the complainant, but apparently lost his patience and acted discourteously. But we find sustained with regards to that complaint. Any questions with regards to that complaint? Can I get a second for sustained for discourteousness?
Second.
All right. All in favor? All right. Looks like we're unanimous with all in favor. Allegation 2, officer physically abused complainant and handcuffs him tightly and placing him in a hot car and denying him water. From the body-worn camera footage, this is exonerated. Their actions were proper with regards to his treatment while he was being taken in. Any questions with regards to this allegation 2? Can I get a second?
I may have missed it, John. If you can, I'm a little confused about how the finding was exonerated here for this particular allegation.
For physically abused the complainant?
Yeah, but yes.
So when they took him in, there wasn't much force used with regards to it. They did loosen his handcuffs after a bit when they were staying too tight. So the force itself didn't warrant excessive force.
And maybe not all of it. Let me be more specific.
Okay,
I'm sorry. I guess it was the part with the placing him in a hot patrol car, that if it was the belief of the officer that this person required medical attention, was that in?
Oh, well, they kept the door open in the car and provided water. Could you explain more with regards to the hot car? I'm not sure how to.
The windows and doors appeared to be open, from what you could tell from the body cameras, and all of the police officers indicated that the windows were at least partially opened.
Okay, and that's why I said I may have missed it.
So I suppose you could call that unfounded, or that their actions were exonerated as being proper. I don't know. That's.
You want to we could, okay. Well, I was saying because the car windows were open, they were providing him any assistance. It wouldn't be that's why I was saying exonerated, because it wasn't, from the footage we saw, they weren't putting him in a situation that was, he was unduly, not feeling well, right? Oh, I am so sorry. I apologize.
If I can just remind all the membership to try to speak directly into the microphone. I know we are getting accustomed to this, so.
I don't know if that's going to do it, though. But I said exonerated because they weren't in any way putting him in a situation that was unsafe or dangerous, putting him in a car that the windows were down, the door was open, and they were having communication with him to monitor him, would be exonerated. It wouldn't be unsustained. From what we saw, it wasn't a situation that they were putting him in a physically inappropriate place. So that's why I feel exonerated is okay.
Yep.
Okay.
Thank you.
So we had a second for the second finding of exonerated with regards to physical abuse. All right. Can I get a motion? Can I get a all in favor of the motion? Good. Thank you. All right, Batman, good? Excellent. Okay, moving on to 3. Allegation failed to take complainant's allegation of sexual harassment and environmental crimes. This was also exonerated with regards to the female officer was not in the room and the individual took his own shirt off. So that whole harassment aspect was was not founded. Also, with regards to environmental crimes, there wouldn't have been an appropriate charge related on what APD is able to do with regards to that kind of allegation. So that would be exonerated, because there were female officers present with the arrest, but it wasn't put in a situation where he was inappropriate, in a situation that appeared to be inappropriate with regards to the video footage that we saw. Second for that? Okay. All in favor?
Aye.
All right. For allegations, the complainant was
Mr.
improperly...
Vice Chair, can we get a vote from?
Oh, I'm sorry,
Pat?
Batman, yeah, he's thumbs up. I apologize. He's all good. I apologize, I should say that. Thank you. The complainant was improperly arrested with disorderly conduct and detained for psychological evaluations. We are finding sustained as with regards to this because, and this was more improper arrest procedure because the appropriate incident report was not filed with related to this person being taken in. So that is sustained. And that was due to the officers not filing the appropriate paperwork with regards to either mental hygiene law or with the complaint of disorderly conduct. Can I get a second on sustained for improper arrest procedures? Second, Batman's got my second. All in favor? Okay. All right. Allegation 5, the complainant was discriminated against, biased by age, nationality, color, or gender. We find this unfounded and not occur to misconstrue because there's no evidence related to that, that he was singled out because of any of those identifying factors. Can I get a second for unfounded?
Second.
All right, Emily, thank you. All in favor of unfounded with regards to discrimination? Batman's good with that too. Full. All right. Allegation 6, police did not seek proper medical treatment and complaint with the the complainant's dog, forced to make a decision about the dog's care while under duress and pain. From what we saw, it was he agreed that the dog would be handled by a competent and a neighbor that he knew. It didn't seem like under duress, and it seemed an appropriate way to deal with the dog. So I would say exonerated with regards to that. Can I get a second for exonerated for treatment of the animal?
Second.
Second, all in favor? All right. The police forced the complainant to disrobe in presence of a female officer. Just like we described, he wasn't forced to take anything off. There was, in the room that he was in, there was no female officer. It was closed when he started to disrobe himself. So this would be unfounded from the video evidence with regards to the finding. So number 7, unfounded for being forced to take his clothes off. Second?
Second.
Second. All in favor? Okay. Batman's good. All right. That's it. And again, I will make recommendations after I see the personnel reports for the individual officers. I do apologize for that. All right. Next is CC 2023-010.
Okay, this is a very sad case. As the complainant's son was being pursued by police along a city street, his car struck another car that was crossing an intersection, and a young man in the back seat of the second car was ejected and died at the scene. The complainant's son abandoned his car and fled on foot before being apprehended by the police. The complainant alleged that the pursuing officers chased her son at high speeds and rear-ended his car, forcing it into the second car. The son was injured and, the complainant said, brutally beaten at some point while in custody of the police. The complainant, who owns the car that her son was driving, also objected to the fact that the car was impounded and that as of the date of her complaint, 2 months after the incident, that the car had not been released. body cameras show that 2 officers found the complainant slumped over the wheel of a car in gear in the left lane of Central Avenue at Lake Avenue at about 10 o'clock at night. They roused him and directed him to put the car in park. He turned onto Lake Avenue, but then accelerated and turned again on Bradford Street, and the police pursued him. A street camera on a private business behind private business on Central Avenue, but behind the business, then shows that on Bradford Street at Ontario Street, the complainant's car hit the second car, and which was then crossing the intersection. The car spun onto a sidewalk, and the son's car continued down the street a few feet up Bradford Street and appeared to hit 1 or more parked cars. The police pursued the complainant after he left the car. The street cameras show that the complainant's son's car was moving at a very high rate of speed. A traffic safety officer later reported that what is called an event data recorder from the car recorded his speed at 81 miles per hour. And the street camera then also shows the police car pursuing 9 seconds later at a much slower speed. And there's no contact between the police car and the complainant's son's car. After the complainant's son was apprehended by the police, he was handcuffed and walked back to the area of his car, and at that point, the cameras don't show any visible injury to him. He did tell a sergeant who arrived on the scene that he was injured, but he couldn't identify how or where he was hurt at that point. Then another officer was assigned to guard the complainant's son, and suddenly, still handcuffed, he took off and was chased by that second officer and tackled, and he comes out of the scuffle with blood in his mouth, which an EMT later determined was the result of him biting his tongue. And the medics also declared on the scene, according to the body cameras, that his breathing was a little shallow and that he had severe swelling to the side of his face, and he was taken to a hospital. The officer who tackled him filed a use of force report and indicated that the complainant's son sustained bruises, swelling, and cuts to his lower jaw and the left side of his face. The son was incarcerated and could not be interviewed, and the officer who subdued him and tackled him to the ground is no longer on the police force. Other than that, no further investigation is possible. I would find that the complainant's allegation that the pursuing officers chased her son at a high rate of speed and forced his car into the second vehicle is unfounded. The street camera shows that the patrol car was proceeding at a much slower rate and made no contact with the complainant's son's car before it hit the vehicle in which the man was killed. And the allegation of excessive use of force also appears unfounded. The man's initial apprehension by the 2 officers who pursued him was brief, and he offered little resistance. His face doesn't appear cut or bruised after the initial apprehension. And after he escaped and was recaptured, it's clear that he's bleeding, but there's no indication that he was beaten or that force other than what was needed to subdue him was required or used. And as to the complainant's concern that her car had not been released to her for 2 months after the incident, a general order does permit the police to impound cars that are either the evidence of a crime or a car involved in an accident that results in serious physical injury or death. So that her car was still being held while charges were pending against her son does not seem improper, and I would find that the police were exonerated on that allegation.
All right. Any questions from the board with regard to this case? Is the complainant present or
I have a
online?
question.
Oh, go ahead, man.
I have a couple of questions. So, one, I understand the impetus behind exonerated when you say the police were trailing a safe distance away, or what seemed to be 9 seconds a safe distance away, and there's no incident where they contacted the other car, so that couldn't happen. Okay, cool. When it comes to the use of force, is there body cam footage of that incident? I'm wondering how, even among tackling someone, you bite your tongue and then hit the side of your face several times. That doesn't seem to be consistent with a tackle or a fall. I'm wondering how much do we have as far as that to call one way or the other? And then the other part is, from APD's perspective, what is the process of releasing those vehicles? If it's part of an ongoing investigation, okay, but if it's someone else's property or was reported stolen or something like that, is there no instance where the car is returned to them? Is it typically held until what point? So I'm just wondering about that process.
For the first part, just with regards to the body camera footage, when we saw there was no striking of the individual, he was tackled when he was trying to flee while handcuffed and arrested, and the fall was what I saw, and the body cameras were on. With regards to the police seizure, car seizure procedure, I'd like to defer to Lieutenant Riddy to probably get the better answer with regards to that.
Hi there. So the specific questions you had was relation to property and cars, correct? That's what we're trying to gather.
Yeah, the car was being held, I think they said a couple of months even after the initial arrest, but it wasn't the person's property. So I'm wondering, what does that process look like? If someone gets arrested in someone else's car, is that car held until this person's sentencing or until the investigation is complete? What does that look like for someone else to get their property returned?
It depends on how the property is involved. If it's tied up into an investigation, then it's till the conclusion of the investigation. You know, and that could be months. That could be a very prolonged period of time. It really depends on the involvement of the vehicle. Like if the vehicle's involved in a homicide in some capacity, you know, that could be held up until the trial itself is resolved. If it's something that is not of that caliber, there are other avenues as well for property being turned over to people in a much more expedited fashion. Again, like stolen cars, unauthorized uses, things like that, those are typically, I mean, unless they're tied to some other very major crime, like those can be turned over same day in some ways, or they're kept for safekeeping until we can make contact with the owner. So something along these lines, this would fall underneath the category of it being held until the investigation is complete. I mean, you have a fatal motor vehicle accident that was spurred on by police involvement, so that's going to wind up getting the attention of not only OPS, but that's going to get the attention of the Attorney General's office. That's going to get a lot of different factors involved, so we could very well hang on to that car for a very prolonged period of time.
Thank you so much.
I can tell you by reading the newspaper that this individual was only recently, in the last couple of months, sentenced.
So that car might have been held up from that, if that's a reason thing. Also, the officer that was involved with stopping him when he was trying to flee is no more with APD, just heads up.
So, Lieutenant Reddy, with that being the case, if the person has been sentenced, would there still be a necessity at that point to hold on to the car, or would the car be able to be released?
I don't know the current status of the vehicle, so I don't know if it is released. I don't know if it's still within police custody. I mean, I know that this complaint's resolution was, let's see, it looks like this was reported out in 2023. So, I mean, there hasn't been any follow-up from our office since then, as far as I know. And that would all be in the hands of CIU. Our scope of investigation would have been just in its preliminary stages if there was a reason for it to have been impounded and kept. So, again, I don't know the specifics on that vehicle at this moment. So I don't want to say one way or another. My interpretation would be that the investigation is if they're sentenced, it's complete. But again, I don't know if there's something else involved with that vehicle or if it's since been returned.
Thank you so much.
All right. With allegation, are we comfortable with that? And complainant's not present, I don't believe. First allegation: officer pursued the complainant's son at a high rate of speed through the city. Looking at the video footage related to the pursuit, we find exonerated. They were well back from the individual that was involved in the crash. Can I get a second for that motion? All in favor? Batman, with regards to the pursuit? Okay. Unanimous. Allegation 2, officers crashed into the driver, the car driven by the complainant's son, forcing him to strike another vehicle. Again, the video evidence does not back this up at all. The police car didn't appear to be involved. Do you have a second for this?
Sure.
All right. All in favor? Batman still up. Good. Complainant's son was brutally beaten, as stated, while in custody, police custody. Again, the only physical force was to stop him fleeing while he was handcuffed. From the body camera footage of the individual and other officers, it didn't seem the force that was used needed to stop him from trying to escape while cuffed. And that's in my opinion. Any questions regarding to this? Any second for unfounded with regards to excessive force? All right, second. All in favor? All right, unanimous. Thank you, Batman. So the fourth and final allegation with regards to this complaint. Police refused to release the complainant's car after the incident. With regards to the information that we saw and the supplemental information we got from Lieutenant Reedy, it wasn't necessarily, police don't necessarily have the ability to release a car with regards to immediately when they're involved in a possible criminal action. So we're going to be exonerated with regards to not properly releasing the car when requested. Any second for this? All right, 20 seconds. All in favor? Unanimous. Thank you very much. All right, last one for the evening. CC 2022-051.
The complainant was the owner of a foreign car sales business, and he alleged that he was berated by a police officer after a false burglary alarm at his company because of an alarm that was triggered by a motion detector. The complainant said he received 3 calls from the same number, and when he responded to the 3rd call, he was told by someone that he believed was a police officer that the false alarms were unacceptable and had to stop. So So consequently, he advised the burglar alarm company not to notify the police in the future because he said he didn't want to be yelled at by the police again. And 8 days later, when there was another burglary, and this time it wasn't a false alarm, he incurred thousands of dollars of damage to his property because the police were not notified of the alarm. But in the investigation of the complaint, Detective Johnson identified the number from which the 3 calls came as coming from civilian employees of the communications team, not from a police station. And the complainant could only state that he was pretty sure that the berating call had come from a police officer. So, inasmuch as the board has jurisdiction only over sworn police officers, I would recommend, as did Detective Johnson, that this be concluded with no finding.
Any questions related to this? It's unfortunate we didn't have a,
Is the complainant here?
I was going to our questions first, and I was
Sorry.
that's right. Any questions with regard to this? Is the complainant present? I'm going to concur with no findings, just, it states that it wasn't a police officer that was involved with this, and it wasn't clear with regards to the, what was even said on that conversation. It's unfortunate that this complainant got burglarized and they didn't call the police because of his requests related to this interaction, but it wasn't on APD officers. So we're going to have to find no finding. We're not saying that this didn't happen this way. It's just it wouldn't be it wouldn't be in our purview to do this, and the evidence that we don't have the evidence to pursue it in a manner anyway, and it's not related to officers. So I'm going to concur with the no finding of the allegation. Any questions regarding this? It's kind of a weird one. Okay, I'm going to make a motion that we go with, concur with the no finding with regards to this complaint. Did I have a second? All right, all in favor for the no finding? Batman, how you doing? There we go, unanimous. That's it for tonight. Before we move to the next thing, I remember someone stating that there was someone in the chat that wanted to make a statement.
There was, but she's dropped off the call.
Okay, all right. Well, if that's the case, then thank you, everyone, for your patience with us. Thank you, Mr. Lawrence, by the way. We appreciate your time.
Were you waiting?
Have a good summer, everybody.
I make a motion to adjourn
Second.
tonight's meeting.
Second.
All in favor?
Aye. Batman, you agree? We're good? All right, thank you, everyone.
Thank you, everyone.
If y'all want to give me back or leave your confidential packets, I'll dispose of them for you.
Thank you very much.
Oh, no, I'm taking mine.
Just to be safe, can everyone, the